Good afternoon. I'd like to call to order this regular meeting of the Lincoln Lancaster County Planning Commission of May 24th, 2017. A printed agenda is available outside the hearing room, and a copy of the full agenda, including staff reports, is available at the front of the chambers with the clerk. The Open Meetings Act is posted just inside the doors at the back of the room. If you parked in the parking garage across the street to the north, the gate is open and no parking coupons are necessary. Out of courtesy for those attending this meeting, the commissioners and the staff, cellular phone usage is not permitted in these chambers during any portion of this meeting, and we appreciate your cooperation. I'd like to have David Carey come up and introduce one of our new planners, please.
Good afternoon, David Carey with the City County Planning Department. I wanted to introduce to you today our newest planner, Colin Christopher. He comes to us from Kansas City. He just started this Monday. He'll be working on a range of items, including things like making sure we have consistent follow-up and increased enforcement on our landscape plan reviews and design standards, as well as working on a lot of public right-of-way projects to help various departments make sure that those projects are moving forward expeditiously and in a coordinated way. And then also some work on our placemaking and creative spaces. So we're very excited to have Colin here, and just want to make sure that you put a face to a name, or put a face to a name. And I don't know if you had anything to say, Colin. But
not really. It's great to be here. I'm looking forward to meeting you all and working with you to improve placemaking and facilitate landscaping and maintenance in downtown and the whole Lincoln area as well. So thank you.
thank you.
Welcome. Great to have you here, Colin. Thanks. Please note the Planning Commission action is final on the following items: 1.3B, preliminary plat number 17004, 1.4 special permit number 1627B, 1.5 special permit number 08004B, 4.3B special permit number 17012, and 5.1A special permit number 17010. Any aggrieved person may appeal final action of the Planning Commission to the City Council by filing a notice of appeal with the clerk within 14 days following the action of the Planning Commission. Planning Commission action on all other items is a recommendation to the City Council or the County Board. The first item of business is the approval of the minutes of the regular meeting held May 10th, 2017. Is there a motion?
So moved. Beckius?
Second, Edgerton.
Jerry, please call the vote.
Beckius,
Yes.
Core,
Yes.
Edgerton,
Yes.
Finnegan,
Yes.
Harris,
Yes.
Washington,
Yes.
Weber,
Yes.
Shear,
Yes.
Hove.
Yes.
Motion carried, 9-0.
The next item of business is the consent agenda. Items on the consent agenda will be called at the same time and will not be scheduled for a separate public hearing unless there is a request from someone wishing to speak or at the request of a commission member. I will ask Jerry to read all the consent agenda items into the record. Once those items are read, she will ask if there is anyone wishing to speak. If you wish to speak on an item on the consent agenda, we would ask that you stand and state that item. That item will then be removed from the consent agenda and scheduled as a separate public hearing under Section 3 of today's agenda. All items remaining on the consent agenda will be voted upon in total with a motion for approval. Jerry, will you please call the items on the consent agenda?
Yes, item 1.1 is annexation number 17004 to annex approximately 283.79 acres more or less for the Lincoln Electric System Operations Center on property generally located at South 91st Street and Rokeby Road. Item 1.2 is change of zone number 3134E for the adjustment of parameter setbacks for the Willow Springs planned unit development on property legally described as Lot 1, Hayman Meadows, 4th Edition, located in the southwest quarter of Section 3-9-7, Lincoln, Lancaster County, Nebraska, generally located at the northwest corner of Lucille Drive and Pioneers Boulevard. Item 1.3A is change to zone number 17009 from AG Agricultural District to AGR Agricultural Residential District for 20 acres on property generally located at Southwest 27th Street and Roxbury Lane, as well as the associated preliminary plat number 17004 for 5-acre lots and 1 outlot for open space on approximately 20 acres more or less with a waiver to block length and water detention on property generally located at Southwest 27th Street and West Roxbury Lane. Item 1.4 is special permit number 1627B to extend an existing wireless communications monopole on approximately 10 feet on property generally located at 921 Fletcher Avenue. And item 1.5 is special permit number 08004B for oil excavation on property generally located at 3601 Waverly Road. Please note that it is final action on preliminary plat number 17004, special permit 1627B, and special permit 08004A, unless appealed to the City Council within 14 days of today's action. Are there any ex parte communications to be disclosed on these consent agenda items?
Jerry, did you read 1.6 in as
Oh, I'm
well?
sorry. I did miss 1.6.
Thank
Okay,
you.
also read into the consent agenda is street and alley vacation number 17004 to vacate the Ash Street right-of-way located east of Colonial Drive and west of South 33rd Street, generally located east of 2702 Colonial Drive. Are there any ex parte communications to be disclosed on these consent agenda items?
I see none.
Is there anyone here wishing to speak on any of these consent agenda items? If so, please stand and state that item.
Did you say that the one at Southwest 24th and Roxbury, that's a final action? Is it too late to speak on that?
That is final action on the preliminary plat,
But now-
17004.
Now's the time to speak.
Yeah, I'd like to speak on that.
Okay, we will remove item 1.3B from the consent agenda for separate public hearing.
Anything else?
I'd like to speak on special permit SP 1627B.
Okay, we will also remove item 1.4 from the consent agenda for a separate public hearing.
One more time, anyone else? Okay, I'd entertain a motion.
So moved. Washington.
Second, Weber.
Jerry, please call the vote.
Beckius,
Yes.
Core,
Yes.
Edgerton,
Yes.
Finnegan,
Yes.
Harris,
Yes.
Washington,
Yes.
Weber,
Yes.
Shear,
Yes.
Hove.
Yes.
Motion carried 9-0.
I'll now ask Jerry to call a request for deferral received prior to the meeting.
Okay, we did receive a request on behalf of the applicant for agenda item 4.4, change of zone 17008, which is a change of zone from R1 residential district to O3 office park district on property generally located at 6969 South Street and 2215 South 70th Street. This would defer public hearing and action on this item to the June 21st Planning Commission hearing.
I'd entertain a motion for deferral.
Move deferral. Core.
Second. Finnegan.
Thank you. Please call the vote.
Beckius,
Yes.
Core,
Yes.
Edgerton,
Yes.
Finnegan,
Yes.
Harris,
Yes.
Washington,
Yes.
Weber,
Yes.
Shear,
Yes.
Hove.
Yes.
Motion carried 9-0.
Is there anyone present wishing to testify on item 17008 today rather than waiting until deferred the hearing date? Okay, we'll now proceed to public hearings. The staff will make a brief presentation. The applicant will then be requested to present his or her testimony, followed by those who wish to testify in support, followed by those who wish to testify in opposition. The staff will then be given an opportunity to respond to the testimony, and then the applicant shall have an opportunity for rebuttal. Each person testifying should state their name and address and shall have 5 minutes to speak unless additional time is requested and granted. The timer will go off after 4 minutes. Then you'll have 1 minute to wrap up your testimony. The Planning Commission will vote immediately at the close of the public hearing, and unless the commission votes to defer action or continue the public hearing. Jerry, please call the first public hearing items.
Okay, item 1.3B will be read as item 3.1, which is preliminary plat 17004 for 5-acre lots and 1 outlot for open space on approximately 20 acres more or less with a waiver to block length and water detention on property generally located at Southwest 27th Street and West Roxbury Lane. This is final action on this item unless appealed to the city clerk within 14 days of today's action. Staff recommendation on this item is conditional approval.
Tom?
Tom Jacob, planning staff. There's 2 items here, the preliminary plat and a change of zone from AG agriculture to AGR agriculture residential on approximately 20 acres. It's on Southwest 27th, a little bit south of West Denton Road. Comes up here. Here's the site in question here. West Denton's up off the map here to the north. Southwest 27th is paved from Denton down to Cardwell Road and gravel the rest of the way. As you can see, there are other acreage development surrounding this. This in here is already zoned AGR. This piece in here is still zoned AG, the last piece. The preliminary plat is for 5 lots. Southwest 27th over here. This is Southwest 24th that is built up to this point. There would be an extension of Southwest 24th. 3 lots on this side and 2 lots over here. This street is actually a street for way in the future after the city would annex this area. Because this is within 3 miles of Lincoln, they are required to do what's called build through to show how these lots would convert into smaller lots. So for example, if you look at this lot up here, there's 3 building envelopes on it. That's to show, so when the city annexes it, each one of those building envelopes could be converted easily into a separate lot. Also with build through, they are required that they can only build the house within one of these building envelopes. So on each lot, there is a specific area where they can pick to build a house on. Each lot will have its own private well and septic system. This area out here along Southwest 27th is shown to remain in an outlot. It's mostly floodplain and floodway, so that's why it's staying in an outlot, unbuildable. And let's take any questions.
Questions for Tom? Guess that's it. Thank you. Is the applicant here?
Good afternoon. My name is Mike Eckert with Civil Design Group. Here today on behalf of Ryan O'Mell, the owner of this parcel. Ryan's here today too. He may speak briefly. Ryan bought this property and is going to live on one of the houses, or the house that existed on the original site. And at this time, he's planning on just platting 2 lots south of where his home would be and remain on a 13-acre lot. And so we created for planning 2 a kind of a phasing plan with this being, with him only planning on doing a couple lots now, eventually subdividing his lot his house is on into the remaining 3 lots. And then ultimately when it gets urbanized, we kind of have a 3-phase project here. And so we will proceed. Staff's been great to work with on this. I think we got everything figured out in terms of the layout and how it was going to proceed. and his ability to continue to take access off of Southwest 27th in the interim, various things like that. So, with that said, we'll be maybe anxious to see what our neighbor has to say. We did have communication with one neighbor to the south who was concerned that the subdivision would have a gravel road rather than paved road, and I explained to her that that is the prerogative per the preliminary platting process, that it does not have to be paved. And then we received one other voicemail that I returned a call on and never got a call back. And I think Ryan spoke to a couple of the owners and to about a couple other concerns, and he can mention that. But so with that said, I'd be happy to answer any questions you have now, or I'll be back up for a rebuttal.
Questions for Mr. Eckert? That's it, thanks.
Okay.
Is there anyone here wishing to testify in support of this item? Are you coming forward, sir?
Yeah, sorry, I just wanted to show you, I got 2 calls from neighbors. Ryan O'Mell, and I guess, I don't know if, Tom, can you help me with this, or? Oh, it'll do, okay. Ryan O'Mell, I live at 6001 Rebel Drive, but we just purchased this property recently. My wife and I were remodeling the house and planning on moving in once it's completed. But as far as the process goes, Mike has helped me out as far as my wife and I with this process, because it's a little bit more involved than what we expected. We thought we could just put in a little cul-de-sac and add a couple lots. As far as the process goes, though, we sent out a letter to all the neighbors surrounding our property, and I got a call from 2 neighbors, and one is located right off of West Roxbury, and I hope I don't butcher his last name, but Chad DeLuey. He's at 2210 West Roxbury Lane, and his main concern was he did not want a through street to go through there now or in the future. And I don't know if he's contacted you or if he's here today, but that was his concern. And then Dave and Kathy Hubertus, they live directly north of us at 8120 Southwest 27th Street, and I met them out at the property yesterday. And their concerns were they wanted to make sure there weren't any street lights, and they did not want a connecting street going through the property and connecting to West Roxbury Lane. So those were the 2 calls that I did receive from neighbors that had questions, comments, or concerns. And otherwise, I'm open for any questions.
Could we get your address, please?
6001 Rebel Drive.
Thank you.
And then 68516.
Could you point there to Roxbury Lane, please?
It's right here.
Thank you. Okay.
Maybe, it's just a short stretch there, and it's not labeled, but yeah, sorry, this is West Roxbury.
And where is the home on the property?
The house is right here,
Okay.
and it accesses off Southwest 27th Street.
Any other questions? Guess that's it.
Okay, thank you. Or
Is
do you
there
want me to
any-
leave this up here, or?
You can take it with you. Is there anyone else here wishing to testify in support of this item? Is there anyone here wishing to testify in opposition to this item?
Hi there, my name's Tom Brookhauser, 8101 Southwest 24th. I guess I'm not necessarily in opposition, I just had questions. First off, we're the property directly south of where this northwest or Southwest 24th would move north. We like our privacy there, but we want to be good neighbors. My questions are this, is there anything, I'm naive to the process, but is there anything in place that would prevent the lots being sold and somebody moving a trailer house in or building a $50,000 house on the property, thus impacting everyone's value of their property? That's a question, I guess. I don't know who can answer that. Also, when I made a call into the planning, I was told that there was a water study done. I want to make sure we're all on our own wells out there, so I want to make sure that the quality and the amount of water available to us existing homeowners would not be negatively affected. And also, I would prefer a paved road. It'd be consistent with all the surrounding neighborhood. All 3 or 4 neighborhoods that surround this property are all paved to keep the dust down and so forth. So I don't know if those questions can be answered by you, or if they need to come up and give us some assurance that those type of things are being considered or not being considered and so forth.
We'll ask those questions of the folks that have already come up once you're finished. Anything else you'd like to add?
I think that's all my questions.
Any questions for Mr. Brookhauser?
Could you point on the map to your property, please?
Right here.
Great, thank you.
I like my shelter belt too, but I realize some of that would have to go.
Thank you.
Thank you. Is there anyone else here wishing to testify in opposition to this item? Please come forward.
Yes, I am Roger Wormiskirch, and I live at 8100 Southwest 24th, right across the street from Mr. Brookhauser. My question was, with the way it's kind of laid out, will there ever be another entrance or exit to that? Only just one for the 20 acres, or is that the normal thing we do? I just asked it a question.
Okay.
It seems like one inlet outlet is kind of...
We'll ask that question of the folks.
Okay.
So
All
is
right.
there anything else, any other
No,
questions?
just fine. I think Mr. Brookhauser covered it all pretty well. I was just curious about the other road, if it's, you know, the Roxbury Lane Road, if that'll be forever forgotten or dead-ended or whatever.
Great. Commissioners have any other questions? Thank you very much.
Thank you.
Anyone else here wishing to testify in opposition to this item? Questions for staff? You know the answers to some of these questions as far as?
Yeah, I believe I can answer most of them. As far as requiring a paved road, the subdivision ordinance allows for streets that are outside the city limits and will not be annexed immediately, that they can be gravel. So that's their option if they want it paved or gravel. As far as houses and how expensive the houses are, there's no regulation about, you know, what the value of the house has to be to build there. As far as mobile homes, there is a law, I think it's a federal law, that says you can't discriminate against mobile homes. But if a mobile home is moved on site, it has to be on a permanent foundation, hooked up to permanent utilities, have the skirting removed, have the axles, the tires removed, and has to have, I think it's some type of HUD, Housing and Urban Development seal on it. And that's allowed by right. I don't know if you mentioned lighting. Street lighting is not required on the streets. And for the street connections, if you can see, Southwest 24th dead ends and Roxbury dead ends. It does not dead end in a cul-de-sac. It's just dead ends with a hammerhead turnaround. When this development was created, it was the intent at that time that these roads would continue in the future at some point when this area develops. That's very common for subdivisions to extend streets to undeveloped property so that that property at a further date can be developed. We want to limit the number of access points onto the main county section roads. As to when Roxbury would be done, that is kind of up in the air. Mr. O'Mell's property between Mr. O'Mell's property and the property to the north, it splits down the center of where Roxbury would continue. So with this subdivision, we would be asking with the final plat that they dedicate half of the right-of-way. We do not build half streets. So this connection would not take place until this property to the north would want to develop sometime in the future. Then they would have to dedicate their half of the street, and then this road would be built.
You might need to zoom out a little bit.
Oh, sorry.
Thanks.
We also have them, the developer or the engineer, show us sort of conceptual layout of where a future street might be so that you can develop property to the north, undeveloped property. The engineer has sketched in a possible road here. Now, that is not, set in stone. That could move in the future whenever this property would come in for a subdivision. So I think, was there anything I missed?
The water study?
Water study, health department reviews those water studies, and they didn't have any issues. Do have John Chess from the health department here if you need him to answer any more questions regarding that.
And then the entrance, is there any other plan for an entrance?
The entrance, until this is built, the entrance will just be Southwest 24th Street until at a later date when Roxbury is built.
Any questions for Tom?
So basically, you're saying that Roxbury probably won't be connected, that kind of loop, until maybe the property is annexed into the city of Lincoln or the property north of them subdivides.
Probably not until the property to the north is developed.
And then I was thinking that for mobile homes, haven't we seen applications before where they have to get permission to put a mobile home while they're maybe constructing like their permanent home?
That's only under the county zoning code, and this is under the city zoning code. But yes, there is a special permit for that.
Okay.
Anything else?
I have a question for Tom. This has to do with sort of the timing and phasing of this development. I like seeing that there's a build-through plan, but just so that I get this also affects the water study. So it looks like everyone's going to have separate waste and separate well.
Yes.
And will that be for all of the eventual
No.
lots, or is this only during phase 1 and 2?
It's for the 5 large lots that are, each one's about 3 acres, so that's phase 1 and phase 2.
And the water study was done based on the need for private wells
For 5 lots.
for 5 lots,
Yeah,
phase 1 and 2.
And I would mention that of those 5 lots, one of them already has a house on it. So it'd be 4 new houses.
4 additional ones.
Mhm.
Okay.
Any other questions for Tom?
Tom, will the applicant be taking access immediately to Southwest 24th and be,
I might have them answer this, but, yes, let me get here, phase 1. What they're showing as phase 1 and what the applicant has informed planning was that he's only interested today, or at the beginning, to do 2 lots here, and then this would be 1 big lot. So he would be required to build the street up to this point where the cross hatching is. And then, I don't know, sometime at a later date, he would then come in and do another final plat over this to show how that 1 big lot would then subdivide into these 3 lots. And at that point, he would have to continue 24th Street up to the edge of his, where it would then turn into Roxbury Lane. So it basically would be built up to this point, and this would be vacant until that north lot would want to develop.
And at that time, the property owner, the applicant, would give up access to Southwest 27th? At what point are they giving up access to Southwest 27th?
Yes, once this is built, he would give up access. Now, this access is gonna stay because there's two houses to the north, and that's how they access their property. It's a shared driveway for three houses.
Thank you.
Any other questions for Tom? Thank you. Applicant rebuttal?
So I will kind of just jump off of what Tom said and a couple things that need a little further explanation maybe. So I'll go into the phase one layout. And so kind of going backwards, Planning Commissioner, he will continue to have access. The area I kind of shaded in there in blue provides access to the existing home right there, and then the two lots to the north. So the agreement we have with planning is, yes, he comes in, he plats the two lots to the south, builds Southwest 24th in the shaded area, stops there. Those two lots take access to that road. So there's really going to be limited traffic in the interim. It's two homes. And in terms of the dust control and those other issues. And then Ryan would continue to access via that shared blue easement area. Then when he goes to phase two, and we have the 5 lots that I've generally got circles around each lot, or within each lot there, he completes Southwest 24th up to where it's still wholly contained on his property. And then at that time, he must take access to Southwest 24th. He gives up his right to go to Southwest 27th. The two neighbors still have that. So the other thing then, and I think, we come across this a lot in projects. We have neighbors on Roxbury who don't want it to connect, and we have neighbors on Southwest 24th that want it to connect. So, but planning has done a good job in looking out for everyone in this, and particularly is asking, and our client has accepted he will be required to place an escrow for that dark crosshatched area to grade and rock that road in the event he's still in phase one and the neighbors to the north do come to subdivide, that the city has the money from Ryan to get that road graded in back to the point where then they could take an offshoot from it and do their property. In the event we're still 15 years down the road, Ryan and his kids are still enjoying their 13 acres. The city's got the money to put that road in, and he's agreed to it, and we'll put up the money for it. So we think that's a fair request, and he's agreed to do that. And so, because as you all know, too often we end up in these situations where, in the past, where it just is a result of the fact that Roxbury came straight into the property line, 30 feet on one side, 30 feet on the other. And so that issue's resolved. So I think it's a pretty comprehensive plan here. So there will be 2 outlets. Quickly on the water study, I think the evidence was very conclusive, mainly in the fact that those of you that might be familiar with this part of the town, right across Southwest 27th Street, about a quarter mile to the north, is a development called The Bridges. It was a project of ours in 2006. And since 2006, they've successfully drilled 41 wells on that property for existing homes in that subdivision. And they're only on half-acre lots. And in fact, the initial well on that property at the Bridges, which is still in place, that they used to feed all the ponds there, the farmer used that and would pump up to 600 gallons per minute. There's some other developments on the north side of Denton that have had plentiful water. And so, suffice it to say, we did a demonstration of wells over the history of time. I think we went back to the 80s up to current, matched the topography of those wells with what would be the underlying aquifer level, and showed that there has really been no fluctuation over the last couple of decades in the aquifer out there. It's very plentiful in this area, and I think the health department obviously agreed. So I'd be happy to answer any more questions. I appreciate the neighbors' questions, and hopefully we've got some of that stuff clarified. It was very hard to see with the phasing, until we put the phasing together, which I think has been helpful for us in planning, and hopefully you guys too.
Mike, is there any restrictions on the type of home that'll be built there? Or?
There's not. Thank you for bringing that up, Chris, because there's not. And as you guys know, the city's not involved in private covenant agreements, but I will say this to the neighbors, that obviously Ryan has bought this property. He's spending the money fixing up the home. And this is not a third-party developer. This is an owner developer. I think he is going to make sure that he has some nice covenants and that the homes that come in there are commensurate with the surrounding neighborhood.
Any other questions for Mr. Eckert?
Yes, I'm a little unclear on when this potential O'Mell Circle will be constructed. Is that going to happen in phase 2?
So that's, real fastly, yes. So that's phase 3. And to get back to your question on the wells, it is that O'Mell Circle only happens when city sewer and water are there. And this is annexed, and then that road's put in if and when they choose to subdivide their land further.
So I'm a little confused when you say that in phase 2, once they build South 24th Street up to the end of his property, he has to relinquish access to Southwest 27th. How is he going to get to Southwest 24th?
He will have to come out of his house here, and he'll have to convert his driveway to come up to that point there.
But his 2 neighbors to the north can still use the Southwest 27th.
They have that legal right today that we can't take away. They would not have access otherwise.
So ultimately, he can still access Southwest 27th as well.
He could. He will be required to construct a driveway, though.
Okay.
Back to Southwest 24th. So whether he wants to choose not to use that new driveway, but yeah, that's the only regulation the city has, is they could demand the construction of the driveway.
Any other questions? I guess that's it. Thank you.
Thank you.
We have one item. I'd entertain a motion.
Move approval, Core.
Second, Beckius.
Discussion? I'm going to support the motion. I think this is a good thing. It fills in, it's already surrounding by agriculture, residential, and so I think that hopefully the questions of the neighbors have been answered, and if they haven't, I'd encourage you to talk to the owner directly. Jerry, please call the vote.
Okay, I'm sorry. This is for action on preliminary plat number 17004. Beckius?
Yes.
Core?
Yes.
Edgerton?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove?
Yes.
Motion carried 9-0. Next item is item 3.2, special permit 1627B to extend an existing wireless telecommunications monopole on approximately 10 feet on property generally located at 921 Fletcher Avenue. Again, this is final action on this item by the Planning Commission unless appealed to the City Council within 14 days of this action. Staff recommendation is for conditional approval. Are there any ex parte communications to be disclosed on this item?
I see none.
Good afternoon, Brian Will, Planning Department. This is special permit 1627B at 901 Fletcher, just southeast of the intersection of North 7th and Fletcher Avenue. This is the property here, accessed by a driveway off of Fletcher. The specific location of the tower we're talking about is right here. What we're talking about today is not a new tower. It's simply an extension of the existing tower from 105 feet to 115 feet. This tower was originally approved back in 1996. There's been a prior amendment raised at about 10 feet. And so this would be the second major amendment to it. So one of the things that we ask carriers to do, is required in the ordinance before we look for a new tower or even extending one is, well, just make sure there's not something else in the area that's easier to go on without extending or building a new tower. There are 3 others in the area, and I mentioned those in staff report. They're not on this map here, but I can sort of point to them. There's one just to the east off of the map here. There's one to the northwest, and there's one sort of about directly west over here. The 2 to the west are already fully loaded, as per our ordinance. Can't require anybody else to go on them. Now, if those carriers can let somebody else go on, that's fine, but by the ordinance, they're at capacity. The one to the east, which is already at 185 feet, so much taller than this one, the carrier, the applicant here did make attempts to contact them. By his application, it's listed as unmarketable. They were unresponsive, would not respond to inquiries for another carrier on that pole. So of the 4 in the area, this one even increased 10 feet in height to 115 is still shorter than all the others. So we find that this one is consistent with the ordinance. We're not putting a new tower up here. We're simply extending one in the area to accommodate another carrier. And so the planning department is recommending conditional approval of this application. With that, I'd be happy to answer any questions you might have.
Questions for Brian? Thank you very much. Is the applicant here?
Yes, I am.
Come forward, sure.
Yeah, Richard Kruger, Crown Castle, representing T-Mobile here. A few points that Brian made. The one tower directly to the east, I believe, the one that's up at 185, that's owned by a company called American Tower. And when you go on their website, this guy on here. There we go. When you go onto their website, they will show their marketable assets, such as here, here, and so forth. This is the location, the address of the tower right here. When they want carriers to co-locate because it gives them money. When you have a 185-foot tower, and I believe there's only one carrier on the tower, I'm not really sure because I don't have access to their databases, but when you type in the address of the tower and it doesn't pop up as marketable, if you clicked on one of these, a brochure will come up with who to contact, what are the open levels and whatnot. So that's the reason why T-Mobile wouldn't go here. As far as this tower, which is the one directly to the west, I believe it's Northwest 7th Street and Fletcher Avenue, through the public notice, the landowner actually called me and had told me that T-Mobile is interested in getting onto that tower as well. That is also owned by American Tower, so I can't speak to it or to T-Mobile's coverage needs. What I can say is, as far as the tower at 921 Fletcher Avenue, they want to hit that I-80 corridor right there. And I mean, frankly, nobody wants to do a tower extension because it costs money. If they could go somewhere else, they would. This way, they're able to hit the coverage needs that they have without building a new tower. And that's about all I can really speak to as far as coverage needs and why we're attempting to do an extension for this project. Yeah.
Questions? Thank you. Is there anyone here wishing to speak in support of this item? Is there anyone here wishing to speak in opposition to this item? Do we have any other questions for staff?
No.
I do have one, I'm sorry.
Sure.
And this isn't so much about this application, but I'm just wondering if that tower is no longer being used, does it need to be decommissioned or?
No, it's being used. There is a carrier on it. So, yeah, we wouldn't want to revoke or remove that special permit. It is still in use.
Okay, thank you.
Does the applicant have anything else they'd like to add?
Well, I could speak to that very quickly. It could be that they
You need to come up forward, please.
Sorry.
No problem.
Again, this wouldn't have anything to do with this application, but speaking as someone in the industry, it could be that they have an exclusive right with a carrier for reserve loading or something like that. But again, I don't work for that company, so I can't speak to it. But just give you a little piece of information there.
Thank you.
You're welcome.
Anything else you'd like to add? Okay. All right, I'd entertain a motion.
Move approval, Beckius.
Approved, second, Washington.
Any discussion? I'm going to support the motion. Only adds 10 feet to the existing tower, so I think this makes sense. Jerry, please call the vote.
Okay, this is for conditional approval of special permit 1627B. Beckius?
Yes.
Core?
Yes.
Edgerton?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove?
Yes.
Motion carried 9-0. Okay, moving on, under public hearing and administrative action, text amendments for, item 4.1 is text amendment number 17006. The 2017 proposed text amendments relating to multiple changes to sections of Title 27 zoning ordinance, subdivision ordinance, and design standards as identified in its entirety on today's meeting agenda. Staff recommendation is for approval. Are there any ex parte communications to be disclosed on this agenda item?
Yes, I was at the Mayor's Neighborhood Roundtable when it was presented there on May 8th.
Thanks, Tracy. Anyone else? I guess not it. Go ahead, George.
George Wesseloff, planning staff. So there's 3 areas as far as these amendments. They include Title 26, which is the land subdivision ordinance, Title 27, the zoning ordinance, and the zoning design standards. Most of these are minor cleanup items that have been collected over various years by city staff. There are a few more substantive changes, which I'll go through just very briefly in a moment. These text amendments have been circulated to the public since March 20th. There was an email sent out to all neighborhood organizations and development representatives. And then, as Tracy mentioned, there was a neighborhood roundtable discussion on the matter on May 8th. So just briefly, I'll just go over 3 more substantive changes that might be of interest to the commission and the public. The first would be found, if you have your main planning commission packet, it should be on page 111. Or if you want to reference the subdivision ordinance chapter, it's chapter 26.23, specifically the section pertaining to lots. And this includes a requirement that if there's a private roadway, that the width of the outlot has to be 60 feet wide. It also includes provisions for the number of dwellings where if there's less than 10 dwellings, a private roadway is discouraged. And the reasons for this, the 60-foot wide outlot requirement is to allow sufficient space for the various items that would be contained in that area, which would include the roadway, sidewalk, trees, utilities. It's to avoid problems that have come up in the past where it's been less than 60 feet as far as the outlot. And then the threshold of the 10 dwelling units is a recommendation to avoid potential issues down the road where property owners, because they're so few in number, might find it beyond their financial capabilities to maintain the infrastructure. So that's kind of the first more substantive change I was going to highlight. The second, which would be found in your main report or main document on page 120, falls under the agricultural use group, chapter 27.62.030, and this pertains to urban gardens. Currently, urban gardens are allowed in all zoning districts except the AG district, and there are 2 conditions under the current ordinance. The first of which is that there is no commodity sold on the premises. The second of which is that approval has been granted by the Lancaster County Health Department. This proposed amendment would allow plants and accessory items for cultivation, but not structures or buildings in the front yard. So it's intended to allow more flexibility for urban gardens. And then finally, I would just mention the more substantive change that can be found on page 143 of the Planning Commission packet, which falls under chapter 27.65 of the zoning ordinance, which is the community unit plan section. Right now in the ordinance, there are what we call density penalties that are in place. There's a 10% density reduction on CUPs or community unit plans that are between 5 and 10 acres, and a 20% reduction for those that are less than 5 acres. And so this proposed amendment would be to help facilitate redevelopment in older areas. There have been several potential redevelopment projects in the past that have been abandoned due to the current requirement as far as these density provisions. So I will answer any questions that the commission might have at this time.
Question for George? Maya?
So question about the notice timeframe for public hearings.
Yes.
So you're looking to change it from 8 to 5, and I'm wondering, one of the main complaints that we get from people is that they didn't have enough time to prepare or find out that there was a hearing, and so how do you weigh that? We hear that a lot. How do you weigh that against the argument that if we make it a shorter period, we have less of a risk to have what happened to us before, which was when we missed the deadline, or the newspaper missed the deadline, and as a result we couldn't hold the meeting, but that was an isolated incident. How do we weigh that against the complaint that we get so often that there's not enough time?
Sure. So there are 3 general ways as far as notice requirements. There's the posting of a sign on the property. There's neighbor notifications via letters that go out. And then there's the legal ad in the paper. The proposed ordinance will not affect the sign posting requirements or the neighbor notice requirements. The only thing that's changing is the legal statute as far as the newspaper printing. The practice would not change. We would still try to adhere to the current practice. This change would just allow flexibility in those rare but cases that have happened where the paper has not been able to publish the legal ad. So we're not going to change anything as far as practice, and it only would affect the legal notice in the paper. Which actually, if we get calls, I've been here almost a year now, and I don't think I've ever had a call from someone that referenced the legal ad in the paper. They usually see the zoning sign or they get a letter.
Thank you.
Any other questions for George?
I do have a couple. On the 27.06.020, it's the classification of use types. It talks about crossing over into different zoning districts. Is there any way you can give me a more concrete example on that?
Sure. That's where you would have, let's say, maybe it's a planned unit development or CUP or other project where there's more than one zoning district involved. The access is approved as part of that development to cross different districts, but at a later point, the intent of this ordinance change is to avoid any issues that might come up, for example, at Building and Safety Department, where they've taken a position that, they would, this ordinance amendment needs to be in the codified for them to, in every case, to be able to allow it. So it's to avoid an issue where you're crossing different districts to access a road, essentially.
So you're really talking more about the access road than anything else in this scenario?
It would be for access via public access easement to and from a public street or private roadway.
And then the next one, right underneath that, it talks about changes, and they talk about the required cap. It might have just been that I was really hungry when I was reading this section, but that didn't make sense to me either.
This is really just moving provisions around. It's not changing the meat and potatoes, if you will, of those sections of the code. It's just bringing them more in line as far as where they should be under the use group table versus where they're at now, which is the I3 regulations. I think you could see in the ordinance there where it's striking out provisions under the I3, under 27.51.030, page 118, for example. So it's just really adjusting as far as location of the provisions.
Okay. About 27.65020, that's under that CUP. And it states that a lot of times when we're doing a CUP in an AG district, we're waiving the height. Is there a particular reason why? Is that for things like barns, or why are we waiving the height on those?
Or maybe just to confirm, are you on page 143?
I'm not on there, I'm on page 91.
91.
So I'm not in the actual code.
Right, this has to do with cases now where there's an ag CUP and waivers for height or area have been granted in the past. I don't have a specific example. Other staff could probably help me on that, but it's essentially because generally there's been waivers needed for those, and so this is to just streamline that so it's not necessary for that.
I'm just wondering why we're having things that are higher than the height limit already.
Actually, we're not. The height limit in the AG and the AGR is 35 feet. So it's basically just saying that in areas where we have an AG CUP, it keeps the underlying AG zoning. But we create all these little 3-acre lots or 1-acre lots in a cluster. And in the past, we've had to note, we waive the setbacks so that they can match the AGR rather than the AG, because the AG has bigger setbacks. So this statement is basically saying when you create the smaller lots in an AG CUP, they'll follow the setbacks and height, even though the height is the same. They'll follow the setback and the heights of the AGR. And mostly it just reduces the setbacks since they have a smaller lot. They don't have a big 20-acre lot.
Okay, so height is kind of,
Yeah, that's the title of it, setbacks and height, lot, height and area. But in this particular case, the height is the same.
okay. And then I have one more here. This is on 27.69.030. It's about the signs.
Okay.
I'm wondering how this change aligns with how we treat signing in other districts, other zoning districts.
Right, in this case, the specific property that kind of led to this ordinance request is located at the northeast, kind of the vicinity of the northeast intersection of Old Cheney Road and 84th. There's an office facility there just north of I believe it's just north of a vet clinic. And it's for these districts, specifically the 01 and 02, which are office districts, and then the RT, which is residential transition, to allow multiple wall signs while still retaining that 25 square foot maximum per sign for individual signs. So it's just to allow a little more flexibility. There would still be an overall limit as far as the coverage of the architectural elevation, which would be 25%.
Right, so how does that compare to, say, like something in the I, in the industrial zoning, or something in the H zoning? Is it very similar? I mean, what kind of sign requirements do we have over there? I just want to make sure that we're not just changing the code for one person.
I'll just maybe answer generally, and maybe if other staff know more particulars, but these districts are not as permissive usually as those other districts you've referenced. So I would suspect that the sign allowances would be more generous, like if it were highway, commercial, or industrial versus these 02 and 01 and RT districts.
I just happen to have the zoning ordinance on my iPad as George was talking. So again, it doesn't change the total amount of square footage of signs. What we just were finding is the first person went out and they put up a sign and it locked everybody else in the office building out, even though his sign might have been just a smaller amount. But 25 square feet in the office in like a B2 district. You can have 50 square feet sign if you're in the front yard, 100 square feet if you're outside. And some of our H districts is a similar thing, 50 foot in the front yard, 100 out. Along the interstate, where you have a much greater distance, we have 150 square feet and over 300 square feet outside. So the 25 square feet is relatively small.
Okay, thank you.
Any other questions? And George, you're the applicant, the planning department's the applicant?
Yes.
Okay. Thank you.
Thank you.
Is there anyone here wishing to testify in support of this item? Is there anyone here wishing to testify in opposition to this item? Do we have any other questions for staff or the applicant? I'd entertain a motion.
Move approval, Beckius.
Second, Core.
Discussion? I think this is just standard cleanup, and appreciate all the work that's been done to accomplish this. Jerry, please call the vote.
Okay, this is for approval of text amendment 17006. Beckius?
Yes.
Core?
Yes.
Edgerton?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove?
Yes.
Motion carried, 9-0. Next item is item 4.2, County Text Amendment number 17009 to amend the AG District Article 4, Section 4.003, permitted uses to move certain permitted uses and place them into Section 4.007, permitted special uses, amend Section 4.005, permitted conditional uses to move certain conditional uses to Section 4.007, special permitted uses, amend the AGR District, Article 5, Section 5.003, permitted uses to move certain permitted uses and place them into Section 5.007, permitted special uses, amend Section 5.005, permitted conditional uses to move certain conditional uses into Section 5.007, permitted special uses of the Lancaster County zoning regulations and adding them to Article 13, special permit requirements. Staff recommendation is for denial. Are there any ex parte communications to be disclosed on this application?
I see none. Tom?
Tom Chaka, planning staff. This is an application by Mr. Williams to amend the county zoning text to move certain uses that are currently allowed by right as a permitted use or as a conditional permitted use, and move those to only being allowed by special permit. Just to briefly go over the difference, a permitted use means that's a use by right. You just go get your building permit, you go build. Conditional permitted is also sort of by right, but there are conditions in the zoning code that are tied to those certain uses. As long as you meet those conditions, you can then get your building permit. There's no review by this board or by the county board for either uses by permitted uses or conditional permitted uses. On page 200 of your report, I've made a table to kind of outline the uses that are being asked for to be moved. And on the bottom, just for comparison purposes, I put in what we have in this city zoning text. Okay, I don't know if you want me to go over all of these, but I can briefly hit some of them. For example, under permitted use in AG, currently dog breeding kennels, public uses, religious facility, and wind energy conservation systems. The date next to them is the date that these were put in the zoning code. So you can see most of these that are allowed by right today in the zoning code have been in the zoning code since at least 1968. Then again, under conditional uses in the AG, you can see those are the uses being requested to be changed to special permitted uses. Some of the newer ones, like domestic shelter was added in '96. That was done at the request of the planning director at that time. And there was, in the staff report, a comparison made between domestic shelters and group homes, that they had similar impact uses. And since group homes had already been allowed by right since '79, the county board at that time approved that 5-0. Going on, under AGR district, permitted uses today, you can see public uses, religious facility, which in the code today it's called churches. We are going to be changing that to religious facility. Airports, and again, wind energy conservation system. The wind energy conservation system, it was allowed as a conditional use prior to that. There was a change done in 2008 to make wind energy conversion systems a permitted use in both AG and AGR. And then if you went over the district height, then it was a conditional use. Oftentimes, these wind energy conversion systems are no larger than a TV satellite dish for personal use. Once again, in AGR, the conditional uses are listed there. For example, cemeteries in both AG and AGR, the only condition is that they be on 20 acres. I think pet cemeteries, if I remember right, that the condition there is that they be 5 acres. So staff feels that these uses have been in the code, some of them as long as 50 years. They, as far as we know, they have not been an issue. Their building and safety has not received complaints about them. These are compatible land uses with AG and AGR district, and we're recommending denial to this application.
Question for Tom? Maya?
Could you just sort of briefly give us an example of how the process would change for an applicant that wanted to do one of the things that the applicant is proposing to move to special permitted uses? You know, what other layers of red tape or restrictions would be imposed on that applicant?
Okay. If it was approved as a special permit, one of these was changed to a special permit, the procedure then would be they would make an application to the planning department. There's a filing fee with that. Planning reviews it, prepares a report, staff report, and depending on whether it would be final action, it could either be final action after public hearing through this body, or it could go on to the county board for final action.
So it's a increased financial burden potentially in fees, et cetera, or representation if you're hiring an attorney or something for the hearing, as well as time frame.
Yes.
Would be longer for these applications to be approved. Or
I think that's a fair statement.
Can I add something? And what is the time frame from the time that the applicant would have to submit to the planning department, get the review, advertise for hearing, have the hearing, and then approve?
It's from the deadline date to apply, it's 4 weeks to public hearing at planning commission.
Okay.
And if it had to go on to county board, that's
Right.
probably another 3 weeks.
3 weeks, yeah.
What communication has there been with the applicant other than the letter that was submitted?
We've had some, for this application, the only communication I've had is the letter.
Okay, thank you.
Other questions? Thank you. Applicant?
Can you leave that up there on the projector, Tom, for me, please? Sure. Sure.
Sure.
Hi, Mike Williams, I live at 7820 Northwest 112th, out in Malcolm. And the reason why I'm requesting these changes, there's a cemetery slash temple, slash mosque being developed right in my backyard. And I think that the community should have a say of what's being developed in their area. So that is why I'm requesting some of them changes. I think some of them changes I'm requesting, like the women's shelter and the kids' home. I could be more than happy to pull them out. But I think like the dog kennel, the airports, cemeteries, true religious things, I think the community should be able to vote on what at least have a say on what's being developed in their area. I know that with just this cemetery alone, it is don't see there's a lot of things that are not being considered. There's no study being done on any water or soil contamination. No study on how that's going to affect our land depreciation, let alone the possibility of affecting our health or well-being. So that's why I'm asking to get some of these special permits. And then if we look at dog kennels, most of them will always increase traffic, noise, especially like with cemeteries. You're going to have increased flow of people coming into that area with cars, people. With dog kennels, increased noise without possible dog markings. With airports, that's pretty self-explanatory. So that's why I'm requesting that that be approved. And I don't see, and like I said, I'm willing to have some of them pulled out as long as I can get some of the main ones approved. Obviously, the city board realized that mausoleum should be a special permit because they just approved it on the last on 4.1. So obviously, requesting the cemetery have a special permit, I shouldn't see any issue. And this is, again, I think that this should be a thing that the community should at least have a say that's what's going on and voice their opinion, because I know when I'm out on my property, I have neighbors coming by talking to see what I'm going to do and how I'm going to try to alleviate this problem. So they're upset that they did not get a chance to voice their opinion on what's being developed in their area. Any questions I might be able to answer?
Any questions for Mr. Williams?
I have a couple of questions.
Yes, ma'am.
Where is the development that you have a issue with in relationship to your property?
I don't have a map of that, so the property is my property is about 300 feet off of the corner of Northwest 112th and Highway 34. It's the road that's either going north and south. One, if you go straight south, you end up in Ponk. If you go straight north, you end up in Branched Oaks.
Got it.
Right. Because that area got broken up out of and 20 acre plots that I'm sure that had to be brought to you guys for approval. We are like I said, about 300 feet off of the corner of Northwest 112th and Highway 34. The cemetery, temple / mosque is developed right on that corner. Is the southwest corner of that or southeast of that intersection.
Any other questions for Mr. Williams? Thank you. Is there anyone here wishing to testify in support of this item?
I'm Dr. Kathy Williams, and I'm Mr. Williams' wife. I just wanted to also point out that in your number 4.1 that you just voted on, there was a point in that you approved mausoleums for special use. And I think that points out that you agree that cemeteries should also be for special use. So I think you ought to consider that when you're looking at this, that if you're thinking about these, these mausoleums for special permitted use, it was 27.63.510 that you just approved for special permitted use. I don't think we're asking for anything different for the Lancaster County. We want that same ability to be able to speak and say what we want in our backyards, just like the city wants. I don't think 7 weeks is too long to allow people to say and have a say as to what's going on in their community. And I think it's important that the people be able to say what's happening in their community. If someone wants to be able to say, I do or don't want a dog kennel in my backyard, I do or don't want a cemetery or a group home or whatever it is that's going on in their community, I think that's part of what people are permitted to say in this country. And I think it's important that we're allowed to say and be able to be a part of planning our communities and be able to be a part of what's going on in our communities. I think that's an important part of why we're here and why you're here and what we do in this community and what we do in our nation is we vote, we decide what's going on, and that we're a community because of democracy and what we do here. And that's why we're here today, and that's why you're here listening to what we have to say today. And so I understand that this is part of what's going on. This is part of why you vote, why you make your decisions, and why you're listening to us. And so I hope that you're hearing what we're saying and not just hearing what the recommendations are by others, but also what the recommendations are by the people. And the people around us and the neighborhood that we're from have been coming to us and saying, I wish we could do something about this. I wish that we could make our decisions. I wish that we had a say. And so we can't change what's happened to us. We can't change what's going on in our community. But we're bringing this forward so that others can. Any questions for me?
Any questions for Mrs. Williams? Thank you.
Thank you.
Is there anyone else here wishing to testify in support of this item? Is there anyone here wishing to testify in opposition to this item? Do we have questions for staff? I've got one. Oh, I guess we do have a.
Good afternoon, Mr. O.
You're in opposition to this item?
Yes, opposition to the proposal, yes. My name is Greg Greeter. I'm an attorney here in Lincoln. My business address is 819 O Street, Lincoln, Nebraska 68508. And I've been working with the United Yazidi organization for about the past year. I think really what the purpose of this motion is there's some concern about a cemetery going in on a 20-acre plot. And there's been some concern that there's a mosque going in. That's probably inaccurate information. At this point, the United Yazidi organization is planning and has already begun to construct a cemetery, which is a permitted use of the property that they purchased not quite a year ago for this very purpose. And they contacted the county board ahead of time and all the proper organizations and understand that this is a permitted use, and they're proceeding along those along that path. There's not going to be a mosque or anything else built in a long period of time there, but there certainly is going to be a cemetery. I think that the proposed amendment, even though there's several things listed, I'm not seeing the
What do you want? You want to
sheet
put
that
something
was-
up that's there?
Yeah.
Okay. It'll be right up. There you go.
Yeah, thank you. Well, anyway, there were several items listed on there that are permitted uses. And I just would like to point out that, one of them is a religious facility of whatever type. Just to set the record straight, there's no plan to build a mosque there. The Yazidi organization is actually a Christian-based organization, and just to set the record straight. But what I think a concern should be is that the Religious Land Use and Institutionalized Persons Act of 2000 is a federal act, and that's been enacted quite some time ago to just really sort of prohibit this type of unduly burdensome zoning regulation that's being proposed today. So, like I said, these folks are just peaceful people that want to build a cemetery, and that's why they purchased the land. They're more than happy to sit down and talk to their neighbors about any type of concerns they have, but as far as the land that itself was previously used for farming, so every spring and every fall there's farming activities and tractors and dust. Most people in a cemetery just kind of lay there and don't make a lot of noise, and there won't be a whole lot of activity out there, but a few times a year when someone's buried. So I understand there may be some misinformation about what's going in out there, but that's what the plan is. And so in terms of low impact or anything that would really change, I just don't think there is. But primarily I just wanted you guys to be aware of, a little bit more aware of what the purpose of this is, what's really going on out there. And of course, I can't say this in one word, but our lupia, I guess, like I said, it is the Religious Land Use and Institutionalized Person Act of 2000. And I think, that if this were to proceed any further, there would be some serious implications with that act, and that there would be some fairly strong opposition to changing what Tom pointed out earlier doesn't really need to be changed. I don't think there's been any problems with it to date, and I don't think what's currently happening out there will change anything going forward. So that's their position and their opposition to the motion.
Any questions for Mr. Greeter? Thank you.
Thank you.
Is there anyone else here wishing to testify in opposition to this item? Tom, you want to come up for a question? Anybody have questions?
I also may have a question for George, because the previous text amendment that we just voted on was referred to a couple of times, and I wanted to make sure that I understood this text amendment that we just voted on. I think I do, but George, would you please explain 27.63.510 to add mausoleums as a special permitted use?
Yes, I think Tom was probably going to address this.
Okay.
But keep in mind, just for everyone, that there are two ordinances. There's the city ordinance, which pertains to the corporate limits in the 3-mile area, and then there's a county ordinance, which pertains to beyond the 3-mile. The ordinance amendment before was for the city ordinance.
Within the city. 27 was within the city limits, the 3-mile.
And the 3-mile, yes.
Okay. And this project, which is not up for discussion because they didn't have to come forward to us, is outside the city limits?
Yes.
Okay.
It's under the county zoning.
Under
The
county.
cemetery they're talking about,
Right.
yes.
But they didn't have to come forward to us because they have the 20 acres they need for a cemetery?
Correct.
Okay.
They did, and they were issued a building permit through Building and Safety Department for the cemetery.
Okay.
There is no permit before Building and Safety for any type of building.
Okay. Thank you.
Maya?
What are the means of and avenues for opposition that anyone living in the county right now? What can you do if you're in opposition to any of these developments as they stand in the ordinance today?
They're a use allowed. If it's a permitted use, they're allowed by right. If it's a conditional use, the only thing you could cite them against is if they're not meeting the conditions.
I mean more as a citizen. So let's say you're in opposition
There
to.
isn't.
Okay, that answers the question. Thank you.
Any other questions? Thanks very much. Applicant rebuttal?
Just to clarify, I'm not asking to stop any from developing anything. I'm just asking to the community to have a voice. And to answer your question, I've talked to many lawyers in the Omaha and the Lincoln area to see what we can do. And I'm pretty much have to, they've said they meet the zoning requirements, and I looked at state statutes. And you can try to sit there and show where they may or may not meet state statutes, but if they meet these requirements, it's really an uphill battle. It's a really uphill battle because, as the lawyer points out, you start bringing in religion and First Amendment, and so it becomes an uphill battle, and that's another reason why I think it's very important that the community really has a say in what's being put in there, and obviously this decision will have no effect on the current development, but just to help clarify some of what the attorney said is yes, the Yazidi community does not, they practice Islam. They're a hybrid religious. Islam, Judaism, and Christianity. They are not specifically Christianity. So there is some misinformation. The other information they don't provide is that their burial practice is within 24 hours, they're going to wash the deceased, wrap in the right cloth, and stick them in the ground. In which, again, that's an issue for water and soil contamination, not to mention any airborne contamination that person might have had. And again, I know it ain't, I'm just providing information so everybody's aware, and I'm not trying to stop. Obviously, I'd like to prevent that because I don't care what kind of cemetery it is. We didn't buy that property so I could live next to a cemetery or an airport or a dog kennel. And then, and also, they are planning on building a temple. And if you look at it, what define a temple is, it's a general category. So they can use it for a lot of things. And so it's possible that they could be going to mosque, and even though the attorney suggested there won't be. So just to try to keep be transparent and provide as much information as possible. But again, the point of this is just so the community can have a say of what's going on. So somebody else down the road don't find themselves in the same situation, or the community that they're currently in. And if I need to sit back and meet with the planning commissioner and say, hey, I'm willing to pull out X, Y, Z, and try to keep these in, I'd be more than willing to do that as well. And so we can at least try to get the community a voice. Because again, I'm not trying to be unreasonable. I'm not trying to prevent anybody from doing anything that they want to do. I just think the community should have a voice and be able to have a say what's going on. And again, if you guys are leery about, like you said, some of them are with a group home or a domestic facility. Like I said, I'm willing to remove some of them out of my application as well. Just so I think some of the nuisance, it goes down to nuisance and public safety, cemeteries, airports, dog kennels, because there could be some issues. So I'm willing to remove some of my requirements on my application if it helps approve this application.
Any questions for Mr. Williams? Thank you.
Thank you.
I would entertain a motion.
Move denial.
Second, core.
Discussion?
I respect the applicant for coming in, and obviously this is your avenue to address some of the issues that are bothering you. But I think that ordinances tend to come into fruition through broad consensus and lots of research and planning, and changing ordinances across the board like this, I think would be pretty traumatic, as well as potentially go against our comprehensive plan, which encourages predictability for developers and for citizens in general. I think I appreciate your willingness to potentially take some things out, but it's we're looking at, it seems like what's bothering you particularly is something that's protected on the federal level, and that is a whole other ballpark, so.
I'm sorry, you can't come up anymore.
I think I should be able to address that question.
No, you
guys
can't.
already-
I'm sorry.
You guys already said that mausoleum should be in for special permit. I ain't asking nothing different. than you guys already
Please sit
approved.
down. Thank you. Please proceed.
I'm done.
Okay, others?
I-
Tom?
Go ahead, Dennis.
Well, I just want to add a comment about the idea and concept of public process in the planning process and in public hearings, which I know we all support. There's a flip side to the public process, which is, as Maya alluded to, protection to property owners, rights of property owners. And I think that we have to weigh both of those sides of the equation. So I'm going to support the motion to deny, because I think that there's a balance here that we have to be cognizant of. Just to add a little bit more to what Maya said, I don't think it's good to ever address a specific issue or a specific site problem with a broad text change like this. I don't think that's good policy at all, so I'm going to support the motion.
Tom?
I too will support the motion for denial. Actually, out of some of the larger context that we've been talking about here today, I actually think that sometimes they are the most important when it comes to allowing community and culture to flourish in an area, including cemeteries, churches, synagogues, and mosques, well, all of the above, to have the opportunity to use their property rights as they see fit to build out community and culture for themselves. That's all.
Others?
I too am going to support the motion to deny. And much of what Dennis said and Maya said is what's on my mind. I believe there's a danger in opening up, changing ordinance for something just specific to one person. If there had been a stampede of people, we might have looked at it differently. But to change ordinance for something that is just very specific for one small group, I don't think is good government. So I too will support the motion to deny.
And I would add one thing that I'm not sure has been mentioned yet. I was very interested in this text amendment because what I couldn't see in the letter was the motivation. And I'm glad that this hearing brought to light what the motivation was, because it makes it more understandable to me. With that said, to do a wholesale text amendment on so many issues without having a lot of information about how many people would be affected by those text amendments, the cost of those text amendments on folks, gives me great pause. And so for that one process reason, I would vote denial on this. I will vote denial on this. The other issue, now that I understand it, is that this really appears to be based on misinformation or misconception on many people's parts, but certainly the applicant has some concerns about an allowable use in the county. And I think that there's much room for conversation and greater education in order to understand what the real issues are here and what the real needs to be concerned or not to be concerned are. And so that I'm going to suggest that more conversation and more openness just in general will make, I think, a better process. And I certainly think the public hearing process is the right process to go about in order to bring issues forward. And for that, I would like to thank you for coming and letting us know what the motivation was. But in the hopes of building a community which is much more open, and I would say that we need to allow cultures to flourish for themselves. And I think that how people honor the dead is very, very important and very individual. And so that's an issue outside of the issue right in front of us. But for those two reasons, I am going to support denial.
Anyone else? I'm going to support the motion for denial. I think this, the rights of the property owner is a very important piece of this. This really does add additional layers of red tape, which, you know, we don't necessarily want, and it's focused on one property and not the county at large. So, Jerry, please call the vote.
Okay, this is for denial of County Text Amendment number 17009. Beckius?
Yes.
Core?
Yes.
Edgerton?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Washington?
Yes.
Weber?
Abstain.
Shear?
Yes.
Hove?
Yes.
Motion carried 8-0 with one abstention. Okay, I'll be calling the next two items together. They are associated. Item 4.3A is text amendment number 17010 to amend various sections of Title 27 of the Lincoln Municipal Zoning Code relating to solar or commercial solar energy conversion systems, definitions, tables, and permitted uses as identified in its entirety on today's meeting agenda. Staff recommendation is for approval of the text amendment. The associated special permit number 17012 to allow for the installation of a 100 kilowatt solar energy conversion system on property legally described as Capitol Beach West Addition, outlots B and C, generally located on the west side of West Lakeshore Drive. Again, this is final action on this item unless appealed to the city clerk or to the city council within 14 days of today's action. Staff recommendation is for conditional approval. Are there any ex parte communications to be disclosed on these agenda items?
Yes, they were talked about at the mayor's neighborhood roundtable as well.
Thank you.
Anyone else? Andrew?
Andrew Theroff, planning staff. So as Jerry mentioned, these are two applications that are going together. It's a text amendment and then a special permit that is dependent on the text amendment. So I'll talk about the text amendment first. This is about solar energy conversion systems, so solar panels. Today, solar panels are allowed under a couple scenarios. One is they're allowed as an accessory use in any district. You could put solar panels on your roof, or if you ever have a building, you could put them, on your property. They're also allowed as a primary use in the ag district by special permit. So this text amendment would increase the opportunity for solar energy conversion systems throughout the city. There's a couple steps with it. The first is that we'd be amending the definition of solar energy conversion system. We would create a small solar energy conversion system that would be 100 kilowatts or less, and then we'd have a large solar energy conversion system that would be over 100 kilowatts. The large systems would be permitted in the H2 through H4 districts and then the I districts, and then by special permit in the ag district. The small systems would be permitted by right in basically all of the commercial districts, the B districts, the H districts, the I districts, and then the AG district. They'd be permitted by special permit in the residential districts, AGR, and the office districts and RT. Couple things to note with that special permit. There are a few additional conditions in the R districts. One is that the owners or operators of the solar facilities, they need to live in the community or in the neighborhood. The idea with that is to support community solar projects. The other condition is that the panels need to be located on an outlot or a lot otherwise not suited for residential development. The idea with that is that residential lots in residential districts should be primarily reserved for houses, residential uses. So this would be looking to make use of generally outlots that would not necessarily have any other use. So going from that to the special permit, this is at Capitol Beach. The applicants are looking to do a community solar facility here on the west side of the lake, just west of West Lakeshore Drive. Here's a little better look at it. So that this is the interstates down here. They'd be looking to put in a 100 kilowatt solar array in an outlot. So this is floodplain, some wetlands, so it's not buildable or usable in any other way. The applicants they have formed an LLC, Beach Solar LLC. It would have up to 20 members. All of those members would be residents of Capitol Beach. The applicants have worked with LES to get all those details worked out. And one of their final steps, if not their final step, is approval through the city. So that's what we're looking at today. I should note something with this. The applicants have decided they want to request a reduction of the yard along this property line here. As noted in the staff report, right now the setback would be per the district, and this is R2 district, so the setback would be 25 feet. They're looking to take it less than 25 feet. They can maybe talk about that a little bit. So that will need to be a new waiver that we'll have to advertise. So the vote on the special permit will need to be continued till the June meeting, June 7th. But we can still act on the text amendment today. That the waiver doesn't affect the text amendment portion of that. Do we have any questions?
Any questions for Andrew?
Go ahead. I did have one question, and this may be that it has to table to June 7th, because my question had to do with the blocks that did not say PV on them. So there's 6 rectangles.
Yeah.
And I was curious if 100 kilowatts was all 6 or just the 4 that got labeled?
I think what's happening is they all say PV on them, but the colors don't really show it. Those also say PV.
Okay.
We just can't see. There we go. There.
Okay, so it's not a phasing?
No.
I thought,
no.
man, is it phasing? Got it.
Yeah.
Any other questions? Tracy, did you have anything?
Sure. Is Interstate 80 considered an entryway corridor?
I believe so, correct?
I tried to find it and I could not find it. I have another question. It talks about, they have that established line of trees there and then kind of a big grade change.
Yeah.
Would you consider the grade change kind of the equivalent of a berm?
Yeah, so the grade change, I think I say 6 feet in the staff report. It actually looks maybe even a little bigger than that when you're out there. But yeah, that would be like a berm, because that would be blocking basically the lower 6-8 feet of those panels.
So if I-80 is considered an entryway corridor, I mean, does that, because it says here, we need to screen for that. I'm assuming that the trees and the grade change would be plenty for that.
Well, I think from the I-80 side, we're not necessarily trying to screen from I-80. This, I would say in a sense, this is a positive thing for the city of Lincoln. I think LES would like it to be very visible, showing that we're pursuing alternative energy goals and ideas. And that's something that the comp plan talks about, is supporting alternative energy.
I know that I don't mean to speak, but I know that in the report, it talks about having glare from these for airplanes. Would that glare affect Interstate 80 traffic?
Department of Roads is reviewing this, but I know there's other circumstances in other places where there's solar panels next to the interstate. But of course, if
It
department
depends on the angles.
Yeah, I mean, if Department of Roads had concerns about it, those would need to be addressed.
Okay. Okay,
Thank you. That was, one of my questions had to do with Department of Roads. And I also wanted to hear from the Airport Authority that they were completely fine with those PV arrays right there. I also wanted to understand what the original purpose of the outlots were in this community. And would the purpose of the outlots be able to would still function in that way, even with these PV arrays there?
Yeah, so these outlots were, it's where the floodplain is and there's wetlands, so they just weren't developable. The Corps has reviewed this and determined that it would have no impact on waters of the United States because of the way the panels are being put in the ground. They won't displace any water or any flood storage. So yeah, I don't think this will really impact the outlot.
Okay. I will have a specific request when we get to June 7th on 1 point.
Okay.
2.3, you can work it out.
Tom?
Andrew, I wanted
Yeah.
to talk more about the outlot, actually. So the outlot currently is not taxable. Is that correct?
Correct, yep.
Okay. So we're looking at putting an income-producing entity to use that lot. Will the taxable status of that lot change? It's an outlot today.
So I contacted the assessor's office and they said, no, it would not change. They don't look at these solar panels as, I guess, commercial uses for taxable purposes. They reference we have the large solar farm on West Holdridge. That's just, that parcel just being taxed as unimproved ag. So the solar panels won't change the taxable status.
I have one. Are you done, Tom?
Go ahead, Tracy.
I did find one other question that I had
Yeah.
written down. It talks about flood proofing the solar panels, and I'm just wondering, how do you go about flood proofing the solar panel?
Basically, they just need to make sure all the electrical components are elevated above the flood elevation, which the applicants have indicated won't be any problem.
Okay.
Yeah, because the portions of the panels that'll be in the floodplain, I think, are just going to be posts.
Mhm.
So they will need to comply with all the floodplain regulations at time of building permit, but it appears that they probably shouldn't have any issues doing that.
Okay.
Tom?
Andrew, could you give me other examples of improvements that one might find on an outlot? For example, my HOA has a well, an irrigation well on my outlot. Are there other examples of improvements that one might find on an outlot in the city?
Yeah, I mean, really with outlots, the most common is something like an irrigation well or, say, a shed to store mowing equipment, something like that. Typically, outlots don't have structures on them. So this, yeah, it's really things that would be accessory to the outlot use, like sheds, things like that, are the most common. And then you have the wells. And now you could potentially have solar panels as well.
Okay, so the city's position and the county's position then is that this outlot, even though it now has a use on it, is still an unusable piece of ground, thus will not be taxed.
Correct, yes.
Okay, thank you.
Other questions? With the setback, does that need federal approval or any type of approval through the highway administration?
I mean, we would send it out to Department of Roads to look it over. So right now we were saying they should be 25 feet off this fence line. They're looking to go less than that. You can see there's still a pretty large setback here, but we'd get confirmation from Department of Roads.
And then do you also get confirmation from the airport authority, or do you already have that?
They just wanted, their review is going to be, there was kind of a general statement about ensuring that it won't impact pilots or people flying into the airport. They didn't think it was going to be an issue. I mean, they didn't have any big concerns. The applicant is going to have to talk to them just to make sure that any of their airport authorities' concerns are addressed. But they didn't recommend denial or anything. They were just looking for clarification on that point.
Thank you. Any other questions?
Just, I think you mentioned this, but all of the confirmations and all of the additional information that we need to have to be able to vote on item 4.3B, we'll have that by the next meeting? You'll have all that?
We were including them as conditions of approval, so before we would do the final approved plans, we would have that information.
Then I think perhaps I should bring up my question on the decommissioning plan. So one of the conditions of approval was to to not require a decommissioning plan for small solar. And I guess because, I would encourage us to strike that and ask for a decommissioning plan, because there still is a facility there. And if the facility falls out of favor, or they know for whatever reason they don't want to use this any longer, I would like to know that there is a decommissioning plan. It was suggested that the method of installation, the ground screws, were such that the cost of salvage would make it worth them taking them out of the ground. But with that said, they also, to meet the Corps standards up out of the floodplain, will be on 1-foot islands, so that they're not lower than the floodplain, or at floodplain, they're a foot above it. And I would ask that we consider asking for a decommissioning plan to make certain that the floodplain is restored.
Okay.
We're not dotting it with however many 1-foot islands.
Yeah, and that may be something to mention to the applicants too, just the exact method of how I think they're just screwing them into the ground basically, but the details of how those ground screws work.
Yeah.
So,
Anything else? Thank you. Applicant?
I'm going to note that Andrew's request, or I guess statement for the waiver that needs to be advertised, that would actually be a delay until the June 22nd or 21st meeting, because we've missed the advertising deadline for the June 7th meeting.
Thank you.
Good afternoon. My name is Terry Whitler. I live at 1940 Surfside Drive at Capitol Beach. I'm one of the residents at Capitol Beach that's trying to organize this community solar project. Lincoln Electric System has a very favorable program for solar energy in Lincoln. Part of it applies to people who want to put solar panels on their home. That does not currently require any approval from this body. What we are looking for is for those of us that for whatever reason would prefer to have a freestanding unit separate from our homes, we're looking for something that would allow us to pursue that. The city zoning code does not currently address that circumstance. We talked with the planning people and they suggested an amendment to the code that would permit certain sizes of facilities within residential areas, and that's what we're applying for. Our goal is to find up to 20 community members that want to contribute to this project, and then we'll install it in this area on the west side of West Lakeshore Drive. This land was essentially left over when the Interstate was created back in, I believe, the early 60s. Capitol Beach Lake at that time was actually twice the current size, and if you drive along Interstate 80 and look towards the airport, you'll see a lot of what looks like white sand, which is actually dirt and salt mixed together. That's the other half of what was Capitol Beach Lake. So the Interstate cut the lake in half. West Lakeshore Drive was then created to parallel the Interstate, and the land to the west side is simply too low to ever be developed. Our property extends approximately 150 feet. If you could display that diagram, please. It extends approximately 150 feet from the street to our fence line, so that gives you a sense of scale. There is probably 200 feet from the fence to the interstate, so we're comfortable that we're not going to have any concerns from the highway people. Questions were raised about reflection. These panels are designed to absorb sunlight, so they are not reflective. Their intention is to absorb sunlight. We don't think there's going to be any concern. As far as the interstate, the panels will be oriented to the south and slightly to the west. So the panels are not going to be facing drivers of the cars. They're going to be facing south and southwest. With respect to aircraft, I do know that since this satellite photo, a couple of these homes already have solar panels on them, on their rooftops. I have not heard from anyone who suggests that that creates a concern. So the other comment I wanted to make is the reason we want to change this setback requirement is we would like to have as few rows of arrays as possible. So if we have to make them narrower, then we obviously have to have more of them. And we like to keep them as few as possible, both for our construction concerns and also for visibility. So with that, I'd be happy to answer any questions.
Questions for Mr. Whitler?
Yeah. Terry, could you explain to me why you chose to utilize an LLC for the creation of the entity that will be supplying these solar panels and owning them?
Yes. Primarily for administrative convenience. We initially talked about the idea that anybody in the community that wanted to could buy 3 panels and somebody else could buy 4. And then when we talked to LES, they said, well, you know, we don't want to deal with 25 people. We just want to deal with one entity. We talked to an insurance broker about how do we cover this, and he said, well, I could write you 20 policies if 20 people invest, or I could write you 1 policy that'd be a lot cheaper if 1 group invests. So it's essentially for administrative reasons. We also didn't want to deal with the situation if we had a hailstorm that came through and my panel got knocked out and Jeff's didn't, then we could argue about whether I should get half the electricity that's generated or not. So it was just for an administrative reasons we went to an LLC.
Okay. And then I also wanted to ask, the program actually gives the LLC a dollar amount as opposed to a credit to an individual homeowner, correct?
Correct.
Okay.
And again, that's administratively, LES didn't want to say what was Whitler's bill, what was Berman's bill, what was RJ's bill, and then give us a credit. So we're going to have to run it through the LLC, and our plan would be quarterly or maybe every 6 months to write a check to people.
Okay. And then how did the use of the outlot come to fruition in terms of your discussions and the text amendment in front of us today, as opposed to using a lot that could otherwise be developable?
Well, that's a fairly simple question to answer. There are only a couple lots that could be developed, and they're at $250,000 each, so it wouldn't make any economic sense.
Sure, for Capitol Beach. I didn't know if necessarily there was a broader discussion for the city as a whole, as opposed to just the Capitol Beach environment.
Not that I was a part of, so I don't know about that.
Okay.
Yeah.
Thank you.
Mm-hmm.
Other questions? Have you set up a decommissioning plan, or do you have anything in mind there? That
I have not. The agreement that we have with LAS will be that its program guarantees us guarantees that it will purchase our electricity at their current rates for 10 years. And at the end of those 10 years, they'll continue to purchase it, but the rate is subject to negotiation. We don't have a plan in place to decommission them. They could, in fact, be removed and located elsewhere, assuming that they're operational. If they're not operational, we intend to have insurance to protect us against hailstorms, windstorms, that sort of thing.
But the LLC will then continue to maintain, they'll have to pay for the maintenance of that.
Certainly. We will maintain them, and you know, we live out there, so we're going to be monitoring them every day. We'll have a system in place that actually tells us how much electricity is being generated on an ongoing basis. So if there was some kind of outage, we'll get almost instant notice.
Any other questions for Mr. Whitler? Thank you.
Thank you.
Is there anyone here wishing to testify in support? And we're talking about both of these items, 4.3A and 4.3B. Again, is there anyone wishing to testify in support of these items? Is there anyone here wishing to testify in opposition to these items? Do we have questions for staff?
I do.
We do. Tom?
Andrew, if a person were to come and buy an outlot and fill it, and then build something on top of it, what would happen to that piece of land in terms of its taxable use?
They'd probably have to plat it as a lot before they could put anything on it. If we're talking like a house
Restaurant,
or something. Yeah,
sure.
yeah, it'd have to be replat as a lot, so then it'd be treat it as a lot.
Okay. My biggest concern here is a company coming in and making an improvement on an outlot that then isn't taxable. You know, and whether or not that, because I love the project. I have no issues with the project. My question is that now we have an outlot that's not taxable, that has income producing improvements on it, that's just the community's not going to tax in any way, shape, or form, and that we're going to allow this company to make gains using real estate that we're not taxing. You know, if I were a restaurant owner, I don't know that I would necessarily feel great about that. So I'm trying to come to terms with the newer use of an outlot that in the future makes gains for a company but isn't taxed by our community. And I'm trying to reconcile that a little bit. And that's why I've asked you if there were any other examples of income-producing entities using outlots for gain that our community's not taxing.
Yeah, and I'm not aware of any others, so.
I couldn't find one either.
Yeah.
And so I hesitate as a planning commissioner to say the community may start using outlots in ways that produce revenue, but yet we can't tax or we won't tax. That's a concern of mine because I don't know that that's equitable to other property owners in our community. Thank you.
Other questions? This one specifically, just because if we would approve this, that doesn't necessarily, does it set a precedence then that from here on out, or are we?
In terms of outlot uses?
Yes.
I mean, we were looking at solar panels as different than a building or something like that. They're just kind of minor structures, really. So in terms of a precedent, I mean, I think these are a pretty unique use, that if someone was doing some sort of other business, it'd be pretty easy to argue that those should be on a lot when they're in a building and those types of things. So I guess I would say it doesn't necessarily set a precedent because this is such a unique type of commercial use.
I'm going to follow Tom on this, because I hadn't even considered this, but I immediately grasp where he's going. And in the staff report, it was noted that these small solar systems would be a primary use on a lot.
Yes.
And so, though I love the idea of alternate energy, finding lots of different ways to power our lives, I love solar in particular. I think this is a great use of an outlot, but I'm wondering about what we need to do because this will set a precedent. This will be referred to in the future. Because I can imagine other outlots being used in a similar way and actually being encouraged in a similar way. So I'd like to figure out how we work that. If we're making an allowance where we say it is so beneficial to the community that we will not tax it, or we're saying we will eventually find a way to tax this.
Steve Henderson with the Planning Department. Just note, you're not actually saying anything about the taxable value of it. That is not in front of you today. What is in front of you today is a very unique set of circumstances. This is a special permit. It allows it in residential areas. You already have the right, basically, in commercial areas to do solar farms. So, and the question that was presented to us that we called the assessor, that was a very small case in terms of we have this outlot if it's recreation, what would you do? It doesn't mean that the assessor is going to say everywhere there's solar panels, they're not going to be taxing them.
Okay.
But again, that is completely up to the assessor's office and a whole other series of bodies in terms of what do they tax or do not tax. They may decide in a year that maybe that makes sense, that regardless if it's an outlot or a lot, We just, in terms of the planning principle here, we could require these gentlemen go through and change it from an outlot to a lot. It's a very large outlot with a lot of survey pins that have to be set. It'd be a pretty big expense to add to them to change it from an outlot to a lot. In our looking at it, we looked at it as that's up to the assessor as to if it has now something that might produce some income on it or not. That's their call. To us, we didn't really see the planning benefit if it was a lot or an outlot. Because frankly, if this use goes away and we had changed it to a lot, we weren't trying to give the impression that this was a buildable property otherwise. And it really goes to, you can say that the panels are structures, but they're not really buildings in the sense of there's no floor area here, there's nothing completely tangible once you decide the solar panels are of no longer any value. And the restrictions we put on in the residential areas that it can't be buildable for anything else, you have to be made up of residents in the area, we haven't made it an incredibly attractive commercial enterprise that suddenly everyone's going to be dashing out to do it, because you have to include the residents of the adjacent neighborhood. So we thought, trying to find that balance between it, we could think of maybe 2 or 3 other large outlots in the city where maybe those residents would decide, hey, we do have a big area that we're not using otherwise. Most outlots have playground equipment on them, or trees or grass, or there's an occasional gazebo. Most associations use it as a recreational use. So anyhow, just wanted to add that because we did discuss whether we should force them to try to make this a lot or an outlot. So that was the reason in there to allow the unique thing of, well, this could be an outlot because it's not really a building itself. This outlet could have been used for parking. They could have started charging each other for parking. I mean, there's other things you could have potentially done that have a benefit, again, to your residents. We wouldn't be a parking lot that you're opening up to general public for self-storage, that type of thing. But other uses you could have said, well, we're going to try to benefit our community members.
Okay.
Thank you. Maya?
Just one last question about the condition 2.3, the no decommissioning plan if ground screws are used. So it sounded like Sandra might be considering an amendment to strike that condition. Do you have a, are you opposed to that, or you, is there a particular reason why you agreed to that condition?
Yeah, I wouldn't say we're wildly opposed to a decommissioning plan or anything, but we did look at it, and it's not going to cost a lot to basically unscrew these out of the ground. The, I guess, abandoned panels, the salvage value of those materials would be worth more than the few hours it takes to take those out. But no, I mean, if you feel a decommissioning plan should be necessary, then we're okay with that. The way these decommissioning plans have worked in other instances is that we've required the applicant to provide a cost estimate for how much it's going to cost to remove, and then a cost estimate of the salvage value, and then if there's any gap in between that, requiring a bond or some sort of surety that would guarantee that extra cost. In this case, it looked like there wouldn't be any extra gap. The salvage cost would cover the entire removal cost, so we felt that an actual decommissioning plan wouldn't be necessary.
Thank you.
Other questions? Thank you. Applicant rebuttal?
No, thank you.
Okay.
I'm happy to answer any questions.
Any questions anybody has for Mr. Whitler? I guess we're all set. Thank you. We will entertain a motion, but we'll call these separately.
We'll need to have a motion for text amendment 17010. Vote on these separately.
I'd entertain a motion.
Move approval, Core.
Second, Edgerton.
Discussion?
I think it's smart to promote renewable energy, and I think this is great, separating out between the small and the large, and I think that'll benefit our community in the long run.
Anyone else?
I love this project. My biggest problem with the project is the commission allowing additional uses of outlots in a way that doesn't benefit the greater community when it comes to an equitable treatment of how one can use land, even if it's an outlot. Because what we're saying is that this party, which is a private entity, can use an outlot which is not taxable for economic gain. And that's okay. I just feel like it's not necessarily equitable to other property owners in our community. Although I love this project. I think it's a great project. I think it's a great use of the space. I worry that the improvement upon the outlot really won't be recognized, and that we're allowing the use of it that's maybe not equitable to everyone in the community.
I think that it's important to recognize, our role as the Planning Commission in looking at these projects and ensuring, within the purview of what we're doing. I think it's really exciting that the neighborhood has come together to support this and to work together and work in concert with the planning department to come up with something that makes sense and will increase our opportunities for sustainable energy.
Anyone else? I'm going to support the motion. I think this is a great project. I agree with Tom and I hope that the assessor looks at this and can decide if this is something that needs to be reevaluated at some point. Jerry, please call the vote.
Okay, this is motion for approval. Beckius?
No.
Core?
Yes.
Edgerton?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Washington?
Yes.
Weber?
No.
Shear?
Yes.
And Hove.
Yes.
Motion carried 7-2. Okay, need a motion for special permit 17012. Staff recommendation is for conditional approval.
Move to defer to June 21st.
Second, Finnegan.
Any other discussion? Jerry, please call the vote.
Beckius? Yes. Core?
Yes.
Edgerton?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove.
Yes.
Motion carried 9-0.
We'll take a 5-minute break. Okay, Jerry.
Okay, I'll just note that item 4.4, change of zone 17008, has been deferred to the June 21st Planning Commission hearing. Okay, moving on to continued public hearing and administrative action is item 5.1A, special permit number 17010 for an indoor kennel with an outdoor area that permits more than 3 animals at a time on property generally located at 222 North 44th Street. This is final action on this application unless appealed to the city clerk within 14 days of today's action. Are there any ex parte communications to be disclosed on this agenda item?
Maya?
I have one. I saw Mr. Friedman and Charlie Friedman at a social function, and we didn't really discuss the application, but we just talked a little bit about the process.
Anyone else?
Thank you.
Thank you. I don't see any others. This is for only new information, is that right, Jerry?
I believe that's what was decided at the last hearing.
Okay. Applicant?
Leon Kilmer, 1531 Kingston Road. Good to see you all again. New information that we did find was in September. Sorry, let me pull this up real quick. September of last year, Camp Bow Wow did ask for the special permit 1013K, which was included in our letter to you, which was the allowance of more than 3 dogs. And you did approve that with unlimited numbers. So our original special permit request was the allowance of unlimited animals. Unless you needed a number, we would do 30 on there. So I just wanted to bring that up if anyone else has any questions on that.
Could you repeat the number again? 103?
1013 Kappa.
Thank you.
Any other questions? Thank you.
Thank you.
Is there anyone here wishing to testify in support of these items that hasn't already done so? Is there anyone here wishing to testify in opposition to these items?
Good afternoon, members of the Planning Commission. Danae Kelkowski. I'm appearing today on behalf of 3 property owners. The Schlossberg Companies, who are the owner of the Tanglewood Apartments to the west, Mr. Herb Friedman and Ron Wilhelm, who you heard from last week. I'm appearing today because we have some additional information we'd like to add to the record relating to this application that we'd like for you to take into consideration as you determine the effect this proposed special permit would have on the surrounding property and on the comprehensive plan. Uses that require special permits are typically uses that are not compatible with other land uses in the zoning district. So in a special permit process, the burden is typically on the applicant and the planning commission to impose conditions that protect the abutting property owners and their land use types and the character of the area. So the first item I think I'd like to have you consider is that the special permit that would allow up to 30 animals within the proposed outdoor area on any given day is not supported by a majority of the neighboring properties. There's a major concern by the neighboring property owners about how allowing up to 30 animals within the proposed outdoor area could affect their existing businesses. Just so I can orient you, the area that's highlighted in red there is the area that's basically the outdoor exercise area. Last week, the applicant indicated that they had walked around to neighboring businesses and talked about, what was being planned at this location. Unfortunately, it doesn't appear that necessarily that communication made it up to the actual owners of the neighboring properties. Mr. Kilmer also testified last week that the neighboring Tanglewood Apartments support and are in favor of the application. However, that's not the case. I think he did stop in and talk to one of the managers at the apartments, but my understanding was they indicated that they did not necessarily have enough information, nor were they the appropriate person to make a decision on support or opposition. In fact, the owner of the apartments did reach out to us in our office and wanted us to convey that they do not support the special permit request with the potentially 30 animals. They feel it could negatively impact their residents of their apartment complex and also their business. Last week, you heard from both Mr. Wilhelm and Mr. Friedman, who have property. So let me maybe just orient you too. So we've got the Tanglewood Apartments over here that are across the street to the west. Mr. Wilhelm's property directly to the east.
This is new information only, right?
Yep. And Mr. Friedman's property to the south and to the west. Aside from these three clients that we're representing, we also reached out to the neighbor owner of the building to the south and also the building to the east that houses Kingery Construction. In both instances, the owners do not support the allowance of up to 30 dogs at any given time on any given day. The general consensus of the owners that we talked to is that it's too many animals, and the conditions of approval for the special permit simply do not minimize the impact this number of animals could have on the existing businesses. The second point we'd like you to consider is that the application doesn't support the goals and objectives of the comprehensive plan for this area. And if improved, instead of promoting economic development within the area, it may actually inhibit the development and redevelopment of neighboring properties to this piece. So the comprehensive plan has an entire chapter, chapter 6, devoted to mixed-use redevelopment. The plan identifies potential for 8,000 new dwelling units to be located within the existing build-out of the city by 2040. While there's a focus in there on greater downtown, at least half of these units, or 4,000 of these units, are anticipated to be located around the city in mixed-use residential nodes and corridors, which would include existing retail centers along major transportation districts. These mixed-use nodes basically combine or allow the maximization of the use of existing infrastructure, and by adding additional units of dwelling units, you strengthen neighborhoods, give them bigger buying power, and also strengthen the existing businesses that are there. So the comprehensive plan has a map in this chapter 6 that identifies some primary areas for mixed-use development. And it's a little hard to see, but you're right within 48th and 40th Street. We've got a big old primary area for mixed-use redevelopment in this area. So you can go through chapter 6 and you can see how this area that we're talking about, the area surrounding the special permit, meets many of the qualifications and strategies for this mixed-use redevelopment. Last week you heard testimony from Mr. Friedman and Mr. Wilhelm that indicated they were exploring redevelopment opportunities, and the plans that they visited with the city so far about do include mixed use, and those are the plans that they are pursuing at this time. So their plans would be taking a combination of some property out there that's undeveloped, Mr. Wilhelm's, and some that's maybe developed or underutilized, and turning it into more of a mixed-use development. So while approval of this special permit may be beneficial for redevelopment of one parcel, I think we'd argue that it does not necessarily support the future redevelopment of the entire area, and in fact may inhibit redevelopment of the area. So in conclusion, I just want to bring up those two main points, but in conclusion, I think we support Mr. Kilmer's reinvestment and reuse, of his property. However, we're asking you not to approve a special permit that allows additional use above and beyond what would be conditionally allowed on his parcel, as it has a large potential to impact not only the existing users out there, but also their ability to do redevelopment in the future. And I'd be happy to answer any questions. Mr. Wilhelm and Mr. Friedman are also here if you had additional questions for them.
Questions for Ms. Kalkowski? Ryan?
So if I understand you correctly, you're not your clients are not asking us to deny the permit, but rather stay within the 3 dogs max outside.
I thought they're already allowed the 3 dogs by the conditional.
Yeah,
It's a
that's what I
conditional
mean.
use, so I think we are asking for the denial of the special permit that would allow them to go beyond what the conditional would allow. The conditional would allow the 3 dogs in the,
But you're not saying the use itself is incompatible. You're saying it's the number of dogs.
it's the number of dogs, I think, that causes the largest concern.
And then, is there any room for compromise here between the, just kind of across the board, the number of dogs outside is there an avenue for allowing some of these kind of buzz creating?
Right, and I have-
dock diving and if so, what's kind
Right.
of the magic number?
And I'm representing, 3 property owners. I'm not representing, because I just want to be clear. Let me get there we go. My map going the right direction. I'm representing the property owners in black, so the apartments and Mr. Friedman, Mr. Wilhelm. These 2 are very clear that they don't support the 30 dogs. I'm not in a position to negotiate for them and see whether they would accept something less. I know my clients who have the property directly adjacent to it are not willing to select or to accept something more than what the conditional permit would allow because of the impact they think it would have on their property.
Even if it would be a limited number, say a limited number per year of these larger events, still no?
That's a no.
That's a no.
Okay, any other questions? Thank you.
Great, thank you.
Is there anyone else here wishing to testify in opposition? Do we have questions for staff? George, I guess I passed you up the first time.
I do.
Okay. Sorry about that.
That's all right.
Hi.
Hi, George Westhoff, planning staff.
The applicant's attorney submitted correspondence stating that the planning staff report selected the 30 number. Applicant is willing to accept this condition and comply. Is that correct, that planning staff selected the number 30?
No, I think that was produced by the applicant. I'm not aware that staff specifically picked a number as far as the number of dogs.
Okay. Thank you.
Any other questions?
Could you
I do have a question for George.
We'll have you rebut in a little bit.
Okay, I was just going to answer that question.
Yeah, we'll bring you right up.
I know that we recently just changed the zone from H2 to B3, and the primary reason behind that was for parking requirements and things like that. If they were still in the H2 zoning, how would that affect this dogs outside, animals outside? Would it still be 3?
Steve might have to help me on that. Off the top of my head, it would make no difference, okay?
It would make no difference?
No difference.
Okay. And so as I'm looking at this chart that the applicant provided us, it seems to me that the only place that unlimited animals outside would be in the B4, which is primarily in the downtown, and then also like in AG, which is outside the city for the most part, and then they've got an H4 here. So it's unlimited in H4? Or that was because that was the special permit one that allowed that to happen?
You're referencing the Trade Center permit?
Mm-hmm.
Yes, that permit that the applicant referenced was unlimited. It just was more than 3 animals. That was special permit number 1013K.
Okay, thank you.
Steve, do you want to add something?
I just want him to explain 1013K a little more, so I understand what it meant.
If I could add, just because that's an application that perhaps George is not as familiar with. In the Trade Center, there was a commercial space that was completely surrounded by a parking lot, a very small space. They were going to lease it out for the Camp Bow Wow. They wanted to have some area to stretch the dog's legs on occasion. So they came up with a very teeny little narrow area because they didn't have any parking stalls to spare. And yes, we didn't put a cap on it because we thought the cap was self-evident to itself. It was a teeny little space to have, you probably couldn't fit 30 dogs out there, and they weren't really looking to have dogs out there recreating, enjoying a pool. So it was two really different circumstances. But yes, it did not have a limit. The limit was the amount of space that was even available for dogs because it was such a small property with a maxed out parking lot.
Other questions for George?
Yes, so, in the conditions, it says that if there are repeated violations of the, I guess it's the noise ordinance, the special permit may be revoked. Does the fact that it's in there as a condition, does that make a difference? Or is that the case regardless, or are we adding a protection by putting it in there?
It would be an added protection. It's essentially a revocation clause. That's, my understanding, has been rarely utilized, but if it's in there, then it gives greater ability to revoke the permit.
And without going into crazy detail, what does repeated violations mean? You know, what are we generally talking about in terms of how many over what time frame?
It might be such that I have to defer to Steve Beal with Health Department, but it would be more than just one case. It would constitute a series of repeated cases.
Steve Hendrickson of the Planning Department, Steve Beal with the Health Department is also here. There would really be two different processes. Steve Beal with the Health Department would just be citing violations of their ordinance. And that's a thing. They would notify us that there has been violations. It's in there as repeated because it's meant to be subjective. If there's a violation and 5 years later there's another one, that doesn't really seem to be repeated. Is it 9 months? Is it 14 months in between them? Or is it 3 weeks in between? And so, again, it would be a staff decision. Certainly, it could be something also that somebody writes you a letter and you are all very convinced by the letter that repeated has been meant, and you ask the staff to schedule this for a public hearing. So I'm not saying that is solely a staff decision, but that's how I view it. But I think we would also take, if the City Council or Planning Commission recommended that they think repeated has been met, then we would probably forward it at that point. But it's meant to be, we didn't want it to be 3, and it was a very difficult thing. We think it would need to be also addressed to our measures being taken to make changes so that if there was 1 or 2 violations and then measures were taken and there hasn't been one for a long time, we don't automatically send it to you because it hit 2. But definitely the fact that it is in here as a condition makes it something very different than just the normal, you can repeal any special permit. To us, this is meant to be, if there's disturbance of the peace, then that shows that it really, the number of dogs probably wasn't appropriate, and there was some impact on the adjacent property owners.
Thank you. I do have a question for Mr. Beal.
Hi, I'm Steve Beal. I'm with the Lincoln Lancaster County Health Department Animal Control. Happy to answer any questions.
If this was just a purely residential, like a single-family home, how does the health department work, like with the repeated violations? I mean, can they request someone to get rid of their dog? I mean, how does that work?
Well, we have a pretty defined procedure for how we deal with it, and so it's largely complaint-driven. So you, as my neighbor, call animal control and file a complaint. We're going to send a letter out to the owner of the alleged barking dog, and we're going to send a letter to you letting you know that we've notified this owner, and we're going to give that owner 10 days to remedy this. And if after that time it's known to us that it's not been taken care of, either we get another complaint or one of our animal control officers observed that it's not been taken care of, at that time the animal control officer is going to do more thorough investigation of this alleged barking, and he's going to come out, take statements from the complainant and/or neighbors, and talk to the owner of the barking dog. If it's decided at that time by the animal control officer that a citation needs to be issued because there is a violation of this noise ordinance and animal control, then they have that ability to do that. If it looks like it's being worked on and the problem's, not escalating anymore and there seems to be a formidable plan for how it's going to be eliminated, then, there might be more time in which we would work with all the parties involved. And that'd be the same way we would handle any other kind of scenario where there might be barking dogs.
Does the animal control person have to witness the dog barking? I mean, do they have to experience that, or do they just gather enough information from their interviews?
Ideally, that's what we like, but that's not always possible. So oftentimes we'll use what's called a noise log. So if there's a neighbor or someone that requested that we provide them with a noise log, they'll keep track of it. So that documentation becomes evidence, if you will. So if we write a citation, we have a noise log, we go to court, and the city attorney's office is going to prosecute on this. That documentation becomes more important. It doesn't just have to be an officer observing it. It can be just that, but it doesn't have to be.
Thank you.
Yeah.
Any other questions? Thank you.
You're welcome.
Now applicant rebuttal.
Christy Schroff, 300 North 44th, Suite 116, attorney for the applicant. I just wanted to respond to the question about planning staff selecting the 30. In our original application, we were responding to each of the conditions that are set forth in the ordinance for this special permit. And in our explanation of how the applicant would respond on the number of dogs, we said either unlimited, or if you wanted to select a number, we are recommending 30. Planning staff, when they wrote the report then, selected the 30, and we agreed to go along with that. Applicant has described at length why the 30 and how that number was arrived at, so I won't go into any more detail on that, but I just wanted to explain that point. The other item I'd like to mention is 2 years ago, when this applicant applied for for the zoning change, it was their intent all along to apply for this special permit. In fact, the ordinance itself suggests this is a possibility. It's not contrary to public policy to go seek the special permit if you don't comply with the two less than 200 feet from residential, or if you want more than 3 dogs. It's just another option. And that was the option they intended to use all along. And in fact was encouraged by the Planning Commission at that time. I'd answer any other questions.
Any questions for Ms. Schroff?
Thank you.
Are most dog kennel locations, they're allowed the 30, is that right, or what?
Well, as we pointed out in our letter, the other kennels that we're aware of here in Lincoln, many are not in zoning districts that require or that are conditional permits, but they're unlimited. And so they're more than the majority that we surveyed were that. But in the most recent one, where in fact Steve Henriksen talked about it, it was a conditional permit, which is the no more than 3, and there was no number specified by the Planning Commission.
Thank you. Any questions?
If I just may bring up a couple points as a rebuttal. Tanglewood Apartments is a dog-friendly apartment complex. They have an outdoor use park for their residents also. I promise the majority of their residents aren't trained in animal behavior or animal response like mine would be. Also, touching once again on the development the mixed-use development they're going to do. The apartments they're wanting to bring in are also dog-friendly apartments. Once again, they're going to need an outdoor area for dogs. many of the, as we pointed out, many of the existing kennels, daycares have unlimited numbers. Yes, while it may be part of the planning staff assumption that, you know, a small area of 20 foot by 80 foot is self-explanatory, there is no law or ordinance saying you can't pack in 30 dogs into that small area. Granted, we're going off the studies that say anywhere from 75 square feet to 100 square feet per dog is the minimum needed to safely house them. In fact, we're trying to leave that even farther open. Also, with these unlimited dogs out there, while I understand their concern about noise, there's never been a noise complaint on any of these other kennels, and they are located immediately next to businesses throughout the city. Camp Bow Wow down on 56 and Highway 2, looking to relocate further down south. Woof right downtown here on 19th and P, I believe, 19th, 20th on P. They're opening a second location down right next to a high school, and Fire Spring down on South 14th. So while we understand the concern, it's also a concern for us for noise. We don't want barking dogs. I want happy dogs. I don't want annoyed dogs. I also don't want to hear barking dogs. My 3 dogs start barking at something in my house, I immediately quiet them down. They're inside, and I still want to quiet them down.
Any questions? Thank you. I would entertain a motion.
Move approval, core.
Second, sure.
Discussion?
I want to thank everyone who allowed us to table this for another couple of weeks, and I appreciate getting the extra information, the additional information on this. It's made my understanding of this issue more complete.
Anyone else?
I agree. Thank you for the extra time. Some of the new information that has been brought up has I have some problems with the concept that an outdoor area has unlimited amount of dogs that could potentially go into that space. Although that's not what's before us currently, I don't know that that's really an acceptable standard. I don't know that, we look to other areas of code here in Lincoln that allow a certain number of animals, either per dwelling unit or if we're talking about fowl per square footage. And while those don't apply to this zoning district, I think it's relevant in that there's recognition of a problem that animals can create when they are adjacent to other uses. And I don't think, for example, in my opinion, I would ever think that an unlimited amount of animals in an outdoor space is appropriate, regardless of the zoning. That's not something that I would imagine I would support. However, what we have before us now is the number of 30, and about over 3,000 square feet of external use that these dogs would occupy in this area. Once again, I can't tell you that I have an idea that that's an appropriate number, but it's the number that we have before us. I prefer it to unlimited. And I think that I'll probably support this motion to go forward.
Anyone else? Maya?
So I prefaced this vote in our last meeting by saying if we deferred, I thought I could be more generous in my vote. And I will be with the information that we have gathered. I will support this application as is. The reason I didn't move at the time an amended version was I wanted to heed Steve Hendrickson's advice to be careful about any amendments we threw out there, the practicality of them. And I asked planning to look into some possible amendments that would have limited the number of large gatherings, but we kept running into the enforcement issue essentially, there's no way to really enforce that this is being followed, and as a result, it becomes kind of meaningless, and it seems like it's something that wouldn't necessarily mitigate the opposition's concerns anyway. I thought about reducing the number of dogs, but then we run into what the health department has said. It's really difficult to quantify noise. It's really subjective, and I think I've come to agree that putting as a condition in the permit that repeated violations could be cause to revoke the permit is probably the best protection we're going to get. It is a real avenue with real enforcement. I have no doubt that the neighbors will hold the applicant's feet to the fire on this. The applicant stated that they're willing to be a good neighbor, so it's not necessarily going the sort of animal control route is not necessarily an overnight quick fix if it doesn't work out, but it is a real avenue to protest this if for some reason it doesn't work out. So I will support the application.
Anyone else?
I just want to make a comment about the number. I think Thomas made some really great points. I'm not so hung up about the number. I'm not hung up about the number at all. But what I think we need to remember and not decouple in the sort of discussion here is that the number is tied to a management plan. And I think 2 weeks ago, we heard a very good management plan for how the applicant will control 30 animals out there. And so I don't know that I could ever support unlimited either, but if there was a great management plan for unlimited, I think that's the key here. And even to the point of if there are complaints, I would take the complaint first to the manager and see if there's something that needs to be done from that standpoint before animal control even gets involved. I think, there's the solution. So I'm going to support the motion as I did 2 weeks ago.
Dean?
I was gone last week and didn't hear any of this, so last night I listened to it all, and I didn't realize it was going to be quite as long as it was. And then I dragged my husband and we went and looked at the site. I think Steve Beal would say that the Finnegans are very dog friendly. And I know that people that go to doggy daycare are picky about their dogs. And I think it's going to self-select. I think the dogs that can handle and are good will be okay, and you'll kick out those that aren't. I mean, we haven't ever had a dog kicked out of dog care or doggy daycare, but, the kennel sometimes looks at us. I thought I was very impressed with your management plan, and I do think that the owners will help you select the number that actually is out there, that it will be out there at any one time. And I, for one, am excited about the dock diving. I think that's a fun event to watch, and I think it's a great event to have closer than the Lancaster County Event Center. So I will support this motion and hope that it succeeds, and we will hold your feet to the fire too, I'm sure. So thank you.
Anyone else? I'm also going to support the motion. I really don't think it does inhibit development. I think it just helps the development there with the having animals taken care of as well as the people. And the fact is that area has not been developed for quite some time, at least Mr. Wilhelm's. Enforcement is easy here. It's either calling the manager and telling them, hey, we need to quiet down the dogs, or call animal control. So, Jerry, please call the vote.
Okay, this is for conditional approval of special permit 17010. Beckius?
Yes.
Core?
Yes.
Edgerton?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Washington?
Yes.
Shear?
Yes.
Hove.
Yes.
Motion carried 8-0. Okay, under special hearings, we have item 6.2, or I'm sorry, 6.1, miscellaneous number 17001, to add the Lincoln South Beltway Amendment to the Lincoln Metropolitan Planning Organization 2040 Long Range Transportation Plan. Staff recommendation is for approval. Are there any ex parte communications to be disclosed on this item?
I see none. Mike? 2 minutes? No. Sorry, I just.
Mike Renzo with the Lincoln Lancaster Planning Department and staff coordinator for the MPO planning functions, of which this is one. You have two items. They're kind of tied together. The amendment we're asking to go first. This is the amendment to the Long Range Transportation Plan. The plan was just adopted by the MPO January 13th of this year, and so this is coming right on the heels of that, but there is good reason for that. What the state is requesting is that we update the cost of the South Beltway project as it's identified in the long-range plan. One of the primary reasons for that is for to let the public know what's going on, but it's also so they can program the project for construction. And that's the other part of this you'll hear about. The update is significant in terms of cost, but I think if you look at the history of the project and understand a little bit more on why the cost has increased, I think that'll be helpful to you. The history of the project is quite significant, and we even have graphics for that. That writes that up or upside down? Zoom out.
Brightness.
Brightness.
Sorry.
Okay.
There you
There
go.
we go. You have to get the right.
No, you
I
need
more
increased
training, I
brightness.
think, yeah.
No, you need increased brightness.
You could leave us in the dark.
As you see by the graphic, the history of the project goes back significantly. Actually, after the 1991 Long-Range Transportation Plan, we started talking about this, and the East and South Beltway entered the Long-Range Plan in 1994, and we began developing funding for the study and began a environmental study for the East and the South. In 2009, we found out we didn't quite have the resources to complete the project as defined, and the project came to a halt, and the East and the South portions of the study were separated. So now we're just looking at the South Beltway, not the East. In the project funding as defined in 2013 came from the Build Nebraska Act. That was passed in 2011. With that funding, the project could resume again. It resumed in 2013 with a price tag of $200 million. As we moved along in the study, and we are approaching the design and the right-of-way of the study. So as we approach the greater detail, the brightness is over there. We always like clarity, don't we? Mm-hmm. And as we move through the Department of Roads actually is a lead agency on this now, this project, and are developing this as a replacement for the Highway 2 that runs through the city of Lincoln. So this project will run to the south of Lincoln. As the project became better defined, we have a clear image of what the footprint of the project is, what the interchanges will look like, and what design they will take. So the project limits and the right-of-way limits drive the cost estimates, and those have become more clear as time passes. So with the time, that and along with the timing delays, I've noted in my report 3 to 5% inflation rate. So this is quite significant and significant to the cost. The reason this is coming forward now is that these costs have just become more clear. It's different stages in the project design process. You stop and reevaluate the project costs based on the information you have at hand. This was the timing of that. We wanted to update the long-range plan so that we could continue programming that and program that for construction. As you see by this graphic, we've begun to look at the right-of-way and focus in on design, and we still are on schedule for 2020 construction. So the project has not fallen back on schedule. It is maintained the schedule, and we have support from the Department of Roads. It's their project. Maybe they have support from us, you could say. So the city and the state are working together to develop the complete funding package for this project. We would like it to amend it to the long-range plan so we can move ahead with those plans. I'm open for questions. We have members from the State Department of Roads here to provide us any details we might want on the project as well.
Questions for Mike? Thank you.
Okay. And like I said, we do have the state. They've spent all afternoon here.
Gentlemen, why don't you come up just to say something?
Take as much time as you want.
Thank you, Commissioners, and yeah, thank you for listening to us. It was an educational process to sit through your meeting and everything. So,
For us too.
Just real quick, my name is Noel Solik. I'm with Nebraska Department of Roads. I'm the Assistant Planning Engineer, and I work with Mike with coordination on long-range transportation plan, and then also the second piece that he talked about are the City of Lincoln, well, not City of Lincoln, the MPO's transportation improvement plan, and then our associated with that is our Department of Roads State Transportation Improvement Plan. Like Mike said, the project's got some substantial history to it, obviously, all the way back to the 1960s, even bringing forward into 1994 when it finally ended up on the long-range transportation plan for the MPO. The project started development with the Department of Roads back in early 2000s. As a matter of fact, I was one of the designers on that way back when, and took part of that project to a certain point. In 2008, funding, obviously, at that time with the economy and with the situation with highway funding, we had to delay that, so the project got tabled in 2008. And then kind of revived in 2013 after the passing of the LB 84, which we call Build Nebraska Act. We were able to produce funding in order to move the project forward. So probably our biggest thing is, yes, we just, I know the MPO just got done passing their 2040 LRTP that was reflecting $200 million. As part of our development process, as we started the project up again back in 2014, or in that time frame, we were in the middle of a development process where we had to develop a environmental document for the federal highway. And there was a document that was developed previously, but because of the time that had passed, that document had expired, so we had to refresh the document. At that time, we started working on what we call a NEPA document to get the permitting for this project done through federal highway, and have been working on that diligently for the last several years. So at this point right now, we are almost complete with the NEPA document, and at that time we had done a cost estimate where we have our new cost in there that's reflected in our request for amendment. So basically, kind of like what Mike said, it was a refinement of our design, our development as we got further along, started understanding better the environmental issues, specific design considerations that increase the cost. There's also the amount of time that's transpired, and when you're talking $200 million, you do have to take that inflationary factor into consideration, so that's a big part of it. We're also in the middle of our right-of-way process, and there is a substantial right-of-way issue that we have to deal with here, so we're being very conservative with that. So moving forward, though, it is in our state transportation improvement plan, and it's in our program. The project is programmed to go. We mean to build it. As we're into final development and into design, we're going to be looking at, trying to sharpen our pencils, see if there's things that we can save on. We're with this size project, we're going to be looking at a value engineering study during the design phase to see if there's places where we can find economies, as part of that process. So, just real quick, if you do have specific maybe design questions, I did bring the design engineer that is managing that project. So if you have any questions for him, or for me too, I'd be glad to answer.
Come on up. You've been patient with us. So.
Brendan Schmidt, Roadway Design Division. I'm the Assistant Roadway Design Engineer for the project. If you have any specific questions about the project, you're aware of it.
Any questions?
I don't.
No, I'm quite aware of this project. It's weird how your life can come back on you. I actually did federal review on the NEPA document in 1994.
Okay, you have some serious history with the project.
As far as schedule goes, I don't know if you guys are interested in that. I know Mike showed that graphic there. The environmental review process, we're doing a draft environmental assessment. It's taking a little bit longer than what we thought. I know some people had heard that we had talked about having a public information meeting this summer. That's going to be more in the fall of this year. That draft environmental assessment has currently been finalized and is at Fed Highway legal review in DC. And so we're getting through that, and so we'll have public comment here soon.
I'm sorry, my eyes are bad. I can't read the first or the most western overpass or change. What I'm trying to say.
The system interchange there?
Yeah,
System interchange at
the next
Road.
one down.
Down?
Over there. Yeah, is that 33rd or 30?
It's between 27th and 34th. Yeah, it's probably around 35th Street, right in that area. It's at a diagonal because of Wilderness Park. The 27th comes down and diagonals, cuts across. So there might be some realignment there of South 27th Street to complete that, that connection. But it's at a diagonal to protect the park itself.
When this thing is done, there's going to be a big celebration in this community. Really big. Okay, so.
That's for sure.
We need a big ribbon for this one, won't we?
Big one.
Any other questions for these gentlemen? Thanks very much.
Thank you.
I should just ask you.
High tech, boy, that's pretty awesome.
Is there anyone here, or do you have anything else?
No, I'm
Okay,
good.
sorry.
Thanks.
Okay, is there anyone here wishing to testify in support of this item? Is there anyone here wishing to testify in opposition to this item? Do we have any staff questions? And no rebuttal, I'd entertain a motion.
So moved.
Second, Washington.
I think this is a great, exciting project, and we can't get it fast enough, so. Terry, please call the vote.
Beckius?
Yes.
Core?
Yes.
Edgerton?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Washington?
Yes.
Shear?
Yes.
Hove?
Yes.
Motion carried, 8-0. Next item is item 6.2, miscellaneous number 17002, review the Lincoln Metropolitan Planning Organization fiscal year 2017 to 2018 to fiscal year 2020 to 2021 Transportation Improvement Plan as to compliance with the Lincoln MPO 2040 Long Range Transportation Plan. Staff recommendation is conformance with the 2040 Long Range Transportation Plan. Are there any ex parte communications to be disclosed on this item?
I do. I attended the MPO public meeting.
Thank you.
Anyone else? Thanks. Mike, anything to add or anything you'd like to?
I think it's important to point out that we're asked that the TIP, or Transportation Improvement Program, is the implementation element of the Long Range Transportation Plan. So what we're doing is programming 4 years worth of projects and studies. So within that 4 years, we're looking at beginning construction of the South Beltway in 2020. A lot of that's already beginning now with in terms of design and right-of-way. But in terms of the TIP itself, the document programs any project that requires federal funding or federal oversight. So we program funds or projects from not only the state, the county, the city, and any other agency such as StarTran or the RTSC, or any project that has significant impacts on the system or is wanting to seek federal funding, have federal funding or seeking federal funding. So this is the single document that the Federal Highway Administration and Federal Transit Administration look to when they allocate funds to a project. Has it received public review? Is it in compliance with the Long Range Transportation Plan? So has it received due planning process and the community support? What we're asking today from the Planning Commission is their review and their comments, and any public comments that may come forward, either in writing or in person. We will receive comments here as well as at the MPO's Technical Advisory Committee and the MPO's Officials Committee. The Officials Committee is basically our policy board made up of 2 city council members, 2 county board members, the state director of transportation, and as well as the mayor of Lincoln. The Federal Highway and Federal Transit Administrations sit on that committee. They're members, but they are non-voting. It's entirely a local process. I need to point out that what we're asking, our recommendation, is compliance with the Long Range Transportation Plan subject to the South Beltway Amendment. That's key, since if the amendment does not go through, we may have to re-evaluate how we program the South Beltway project in the TIP. But as it's structured with the amendment and with the TIP, we feel that that's a good combination, a good product, and we can move forward with the rest of the design of all these projects that are listed and receive the federal funding that's identified in the program. So it's a combination. This is where we need your support, and we need public support to move it forward so we can continue our projects. I'm open for questions on that as well.
Question for Mike?
How long will the public process be open for folks to comment?
We opened this for 30 days, so we published a notice on May 15th. That went to certain public buildings. We published or posted notices. We sent out an email blast. We have a library of 1,800 email addresses, people that participate or are active in the process. We maintain those email addresses and we send out a blast to each one of them. Some of those on the email list are chairs or representatives of larger groups, so they forward that to their email lists, such as neighborhood groups, business groups, and so forth. We also publish a notification in the Lincoln Journal-Star. That's along with what we do for the Planning Commission, in addition to what we do for the Planning Commission. You'll see a press release from the mayor's office as well. So we try to hit it from every angle we can to inform the public that this process is going on, and we're asking their input. All input we receive will be included in the document, too.
Any other questions? Thank you.
Sure.
Is there anyone here wishing to testify in support? Is there anyone here wishing to testify in opposition? Do we have any other questions? No other rebuttal? I'd entertain a motion.
I'll move conformance with the 2040 long-range transportation plan. Beckius?
Second, Finnegan.
Jerry, please call the vote.
Okay, Beckius?
Yes.
Core?
Yes.
Edgerton?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Washington?
Yes.
Shear?
Yes.
Hove?
Yes.
Motion carried, 8-0.
At this time, anyone wishing to speak on an item not on the agenda may do so. We're adjourned.